Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, couch potatoes. Happy Tuesday. We're here, your internet besties, ready to talk about some more Laura Owens today, as if
Oh, yay.
we didn't talk about her enough on Friday.
Oh,
There's so
we
much.
talk about her all the time.
That's true. We really do. It's ridiculous. But Friday we did a stream during the day, watched the trial, the paternity trial. Then I went on Nick Starrow's show and we listened to the bankruptcy hearing. And then we came back on here to watch the settlement conference. I'll tell you what, afterwards, I was just sitting there like, like my brain cannot comprehend how these people have let themselves get to where they are. Like, how do you just not like, chill the
Right?
fuck out
Right?
and say, no, we're
Right?
done. We're done. Walking away. You lost. It's unbelievable to me. My brain just can't even.
Well, I think we're going to find out today just how they keep getting themselves, because it's like it should be over, right?
Right.
We had the hearing or the trial. Should be over. No.
Nope. We're far from it. Far from
I
it. They
know.
don't go away. They don't stay quiet.
I
They
saw
do
the
worse
timeline.
things.
I saw the outline and I was like, really? Are we doing this still? Good night.
Right? Everybody be like RJ, right? The novelist. And don't forget to like this stream. That lets everybody know where the party's at today. Or if you're part of the replay crew and you don't know who we are, please subscribe, hit the notification bell so you never miss when we go live or catch an episode, because we go live all of the time, every day. So covering Low, soon covering the BAM case. Well, we already started covering the BAM case, but BAM will be back next week sometime. Because we're doing an easy week today before we get into July, because July is going to be wild. And I'm very excited
I heard that.
about it. It's going to be wild. And we covered more BAM stuff. We're going to have some friends joining us throughout the month. And so I'm really excited to finally talk to them. Lots of fun new things coming. Amy H., thank you for becoming a YouTube member. Again, I think that might be an upgrade because you were already one as of last night when I put your name on a spinning wheel. So I don't know. It doesn't show on our end. But thank you, Amy, for your support. We love you. Hello. Good morning, Lady in Gray. Happy to see you. Ms. Wings, good morning. Happy Tuesday. Dan Montana, lurking in their sunglasses because they're cool.
Oh,
One of the cool kids.
I
Happy
was
for
gonna
you to be
start
here.
the stream in my sunglasses this morning and totally forgot.
There's Cindy. Good morning, Cindy. I hope you're doing well today. Say cheese. Good morning to you. Bam. Look, I love how everyone's been changing their little icons to Legos to match our Legos and
Lego
our
pups.
BAM coverage. It's so cute. Natalie did hers too. Where did she go? I saw her up here earlier when she became a member last night. Look at her cute little Lego.
Look how cute.
I know. And then Lig has her Lego. And Say Cheese, her dog Pepper, she turned into a Lego.
Does that
Ham's a
make us
Lego.
trendsetters?
Maybe. If you need a Lego person and that's like you let me know. I'll have Amos do it. I mean, I don't know if the others just did it themselves, but she did ours and she did a bunch of the Legos for some of the other creators like Bruce and Hey Rob and Cheap Daddy and Echoes, which trying to get me on last night, but you were in the chat and I was like, I can't. She'll yell at me tomorrow.
Oh, man. That was a fun stream last night.
It was fun. In fairness, her and Amos did have to chase me down yesterday morning because I way overslept. They had to call Elbow Fee. Elbow Fee had to call me. So, in fairness, because Buffy does not yell at me all the time. That's why I said that. So they didn't have to, not all the time.
Not all the time.
Good morning, Mary. Happy to see you. I promise.
You know, it's bad when I actually have to text your actual phone number and be like,
I know.
Where are you?
You, Amos, and then Elbow Fee called, and I'm like, what? It's not Tuesday. Hello, okay. Hope you're doing well. Hello, Angie. Angie, hope you're doing well. So you guys, we're gonna get right back up on to the timeline. Over what is that in this case, right? It's never close to being over. So just because we got the paternity trial, for those that don't know, we're only still in 2024. It is 2026, and there's still a whole lot of shenanigans to cover because they don't stop. They don't stop. There's LMP. Hi, babes, who was amazing and joined us Friday night. She came on stream and joined us. That was a lot of fun. It was a good time.
It was. I had a super fun time with everybody on there.
Jupiter James and I were in Hellville's chat last night as she was reading like "Are you the asshole?" or "Am I the asshole?" on Reddit. And so Jupiter James and I were in there sitting on our petty couch judging people on the internet. It was fun. And then I didn't know Echoes was on, so then I popped over there after she was done. So, hi Becca. Good morning. Let's be doing work. No, it's fine. I won't tell you.
This is work. Laura Owens is work.
It's so much work. So much work.
So much
Hello,
work.
Bella.
Or at least a lot of brain power.
Does. Oh, hi, Flux. Oh, a Flux raid. Or hi,
Oh.
Winks, and a Flux. I'm barely awake. If you thought I got up early this morning, I did not. Hello, Winks, and a Flux raid. Hello, everybody coming from Flux. So happy for you to
I love
join
it.
us. There she is. Hi, babe. Hope you're doing well today. Man, you must have been on early.
She
Ugh.
was. She was covering Bam and Laura.
Oh,
No.
snap. I know. We're going to have to get together with you very
We're
soon.
gonna have
Flux,
to party.
to talk both, for sure. So keep an eye on your emails. Hello, April. We need a sidekick stream. I know, right? Oh, they're so fun. They're like our male counterparts. Echoes and Jeep Daddy. I'm convinced. Except I don't know. I feel like you keep me on the rails, where Echoes has to keep Jeep Daddy on the rails sometimes.
Yeah, it is. It is kind of an opposites there. Even though he'll claim that he keeps Echoes on the rails.
I know, right? There's our good friend Bill. Guess where
Bill.
he is? I'm gonna go with the
In a
pub.
pub.
It's pub time for you. So probably there. I hope you're having a good day. So are there any appeals being filed with this paternity case? Yes. Yes, in disguise, which by the way, I hope you're doing well. Yes, there. Oh, wait. Are you talking about Low or Bam? Low, yes. Bam, I don't think there's been anything done for appeals yet. So that must be what you're talking about. In the paternity trial, of course there is. Of course there is. Wouldn't be Laura if there wasn't an appeal.
Right
Just an
at the 11th
excuse to
hour.
show off my cute one-eyed pug Stella. She's beautiful. I love her. Look at her. She's sleeping beneath my laptop as I listen to work. Oh, yours does that too? They'll be by your feet snoring away. There's Hellville. Hey, babe. So I was just talking about how we had a good time last night. Yes, thanks for attending my asshole session. Hellville, when I say that out loud, had I not given context just a few minutes before.
Yes,
Yeah.
that would leave me to ask a lot of questions because I'd be
I'm
like,
busy
asshole
lady.
session. What are we doing? Bleaching? What are we doing?
Sunbathing or perineum sunning that I covered on Llama Learns
is
About
that
once.
Oh, that's right.
Yes,
That's
it is a
right.
thing. Don't do it. Don't do it. It's dangerous. Don't do it. It's stupid.
Wait. Well, first of all, that's a risk.
Yeah.
Also, do you just do you just sit there with your butt like?
Oh, there's different
butt cheeks apart?
positions. There's different positions, Buff. I can't believe I didn't talk to you about this. Yeah.
I don't think I
Some
saw
like
that.
to lay
but
on
I
their
just-
back with their legs wide open and spreading. Some bend over and downward facing dog.
Who
And
has that kind of flexibility and core stability? I mean, I'd be like,
mean,
okay, it's too much work.
not me. That's for
Also,
sure.
it wouldn't be you and me as friends if we didn't go back to buttholes or butts or boobs at all. So this is just
Yes.
who we are as people. If that's offensive, I'm sorry.
Oh, she's down. Yeah. Well, good, because I'll be reaching out to people this week to schedule all of our fun July hangouts. Because I had such a fun time with the fundraiser with everybody, but I had to wait until we got to a certain part in Laura where I could, we had to watch Clayton's paternity hearing on Friday because oh, it was amazing. We had waited so long, and you guys were right. It was like it lived up to all of your guys' hype for it. It was amazing. I'll probably have to watch it again and again. Helville would like a Lego. Please, flaming hair and sunglasses at all possible. Okay, hold on. I'm going to screenshot that to send it to Amos because I'm going to forget that in like 4 hours. So, so basically, that's what I'm going to do. Send that to her. Oh, you're probably going to have to send a picture of yourself to her. Well, she might be able to pull one from the YouTubes, but there, that way I know, and I'm giving her a list. She loves making fun stuff. So, anyway, be right back. Bruce is out sunbathing, his beehole. Oh, you forgot you're on your husband's account. Well, that's okay. Make sure Gilbert though subscribes and hits the notification button. Anyway,
like, what happened? Who are these people?
So
how did I get here?
We're right. Like they're talking about tanning their buttholes in the morning. Yes, we are. Speaking of buttholes, so today what we're going to talk about is going to be the same day. We're still in June 10th of 2024. We got Jingras blog to read that, of course, he wrote immediately after the trial.
Right after the trial?
Published date June 10th. So he said in court that he was going to be out. He was going to Europe for 3 weeks. So I imagine he wrote this on the plane. Which, okay.
Much time on his hands.
After the day he had in court, I can't believe you wrote a blog about it, sir. So I can't wait to read it. I don't know what he has to say because yikes. Yikes. And then after that, Laura does what Laura does best. And guess what she did?
Writes a blog?
No.
Files a motion.
No. It's been a while since she does.
Calls the cops.
Yes. It's
one
been
of
a while.
things.
It's been a while since she's called the cops on people in the internets, but guess what? She does. And then we get to read Judge Mata's what's the word I'm looking ruling on the whole thing, which is 19 pages, and I can't wait to read it. I think it's going to be very fiery. So I'm very excited. I heard it's very good. So excited. Don't know what any of this says. People
are we going to be able to get through all that? We know a Laura and a David blog is like 40 pages each.
Well, there's no Laura blogs today.
Oh, okay.
Laura blogs. Excuse me. Sorry. Laura blogs. So then Thursday, if you want to know what we're covering, we have another David blog to read, and then like 5 Laura Medium articles to read. It's all like within the same time frame because, of course, she took right to the internet to put all her thoughts. I'm sure after that, she's going to call the cops on the internet again. I don't understand why people on the internet are being so mean to me. Because you keep saying dumb shit on the internet. Just get off the internet. That's all you got to do.
Okay, so then my thumbnail is wrong.
What? Oh,
because it says DRJ. That was in the screenshot you sent me, so I put it on the thumbnail, but that's okay.
That's okay. We'll switch them out later.
You switched it up on me.
No, I wrote Thursday, or I'm sorry. Yeah, I wrote Thursday above the bottom half. And you need new glasses. I know you just got.
Maybe these are new glasses.
Just kidding. I'm just kidding. It's fine.
I mean, they're old glasses, new lenses.
Well, there you go. All right. So, hello, police. There's people on the internet. So scary. Send them all to jail. They're so mean to us. They're so mean to me, my family, my mom. Hi, Skybell. Sorry you needed a break from crazy Laura. Was watching murder trial in Germany. Baby and 8-year-old strap burned by father's girlfriend. Oh, that's awful. That's okay.
You can watch a murder trial in Germany.
I didn't either. I didn't think you guys did that, do you? That's interesting because I've always wanted to watch trials in other countries, though I don't speak German. So I'll make Elbow Feet watch it and then translate it for me because he does. and he has a bunch of German friends. But no, that's okay. Sometimes you gotta take, a little break here and there. I get it. I get it. All right, so let's get
Well, real
into
quick, let me
sure.
answer a text packet in the chat. She asked where I get my glasses from. I get it from my person that I do glasses, but they're Coach brand.
My person, my glasses guy.
Yeah, I have a dealer on the black market glasses, y'all. It's just wherever I go to get my prescription, the eye doctor, they have all of them on the wall, and this is like the only pair I tried on because I've never had glasses before. This is my first time getting them. So
I love that. Oh, I forgot. We also have the update from the settlement conference regarding Laura's trial, like for felony one. So it wasn't really much of anything. What's going to happen is the trial, they're filing a motion to make it official, but the trial it is continued. It is not happening in August, which is to the surprise of very few of us. And they have another settlement conference at the end of August. So listen, they're going to try to push it out and push it out and push it out. They're going to try lots of things. Laura has a checklist, I'm convinced. And that's probably what's going to happen. But so that's okay. I said I was very busy in the month of August. So I'm not upset about this time. Though I did hear that Clayton and Greg were there and they did speak up because she had asked to travel because, of course, she did. She has this appeal. She needed more time to write for Mike and, a felony, but she needs to travel, guys. And so they
where's
did
she
speak
gotta go?
out.
Where's she going?
I think California. So,
For what?
right. And so they both, were very vocal about that, about not letting her go. And I agree with them. But the judge was, well, she showed up to everything else. And so I'm going to have to let her go, which is what happens. I mean, it's not like she's on bail or anything like that. So
She's got to go harass Michael Maricini. Is what she's gonna go do. Allegedly.
probably, allegedly. So that was the update coming out of that. I didn't really go live with it yesterday because it wasn't really much to do about nothing really. But that's okay. That gives us more time to cover stuff instead of, having an extra, extra, extra crazy month of July, and it's already going to be extra, extra crazy. So we'll see. We'll see what happens. We'll see what happens. Hello, Boots. Hello. Welcome, welcome. All right, so let's get into whatever dumb shit David has to say today.
Dumb shit.
Dumb shit. And in case you missed Friday's stream during the day, because there were many, David is closing down his law firm effectively
Aw.
tomorrow. Tomorrow the 1st.
We will
28th
miss
of
your
June.
ramblings. Your rambling vlogs.
Yeah. But he made that announcement on his own website on Friday. So he's closing down shop. Just in case you missed it, because there was a lot going on Friday. I don't expect everybody to go catch up with things. So, all right. So this is what David has to say for the trial. Okay. If asked to describe the trial in one word, anticlimax. Well, I disagree. I thought it was very climactic.
If you have problems climaxing, you can see a doctor.
I mean, I was impressed. Do I think it should have been longer? Yes, very much so. But I was satisfied, quite frankly.
There are so many jokes in just that one
I know.
sentence. Do I wish it could have been longer? But I was satisfied. That's what she said.
Right. Hi, Berkeley. Helville says something Echoes pointed out was, so your attorney is going to receive the discovery info and you are going to be out of town. That's terrible. I know, right? But see, she's got to do her same tactics she does with everything else in this case too. So in some way, I feel like it's kind of predictable in how far she's trying to punt or move the goalpost. I don't know sports analogies. Don't come at me. All right. So he says it's anticlimactic. Sorry. That's terrible. I suck at humor. I know this. Oh, David. I miss
Look
you.
at you being all self-aware.
And moving on, I am guessing everyone has the same main thoughts. Here are mine. 1, 2 hours for the trial was fucking bullshit. All right, lobster claws for you, David. I agree. It was bullshit. I agree. Nowhere even close to enough time to have a meaningful exploration of the story. Didn't have time to talk to Clayton. No closing. Nada. It was like a New Year's Eve party that lasted from 8 to 10 p.m. That's actually pretty funny, David. I'll give you that one. Who does that? I agree. With point one, I agree. I do not understand why it was only 2 hours. I feel like the guys did get, I mean, it is in their favor, but I feel like they got the short end of the stick to have their voices heard in court because they've been silenced in court as, the defendants and things, right? You have your lawyers, they do all the talking, you don't get to. So I agree, David. Point one, I'll ruling. I don't know where my gavel is, but agreed. 2, the lack of time cut both ways. It unquestionably hurt both sides. Well, David, it's probably a good thing your client didn't have longer on the stand, or she'd probably have even more probable felony charges. So, ugh, I mean, I agree, but also I would have liked to see more. My personal biased view aside, the lack of time hurt Clayton's side way more than it hurt ours. Okay. Our story was short and fairly basic. Did I get a chance to cover everything? Not even close. But we covered enough. And sometimes that's all you need. Sure is, David. Sometimes that's all you need for 14 felonies. Am I right? That's it. Just a little 45 minutes on the stand.
Just enough time to dig your grave.
Exactly. By comparison, Clayton's approach was and has always been to try and drag way too much extraneous bullshit into the case.
Sir.
Do we need to talk about Rule 26? David, if you bring it up, I'm going to be pissed, just to let you know.
What about that 40-page motion for more time? Talk
Right?
about dragging way too much.
Or lunch or any of those things. Hi, PGT. Hi, good morning. Yeah, about that, David. Let's see. I don't personally fault him for this. If he only limited our story to things that happened between May and November 2023, this story is nowhere near as interesting. I thought it was pretty interesting. So did everybody else. And boring stories don't sell very well. In my experience, simpler is almost always better. David,
What?
you are not a simple. Nothing you do is simple. All right. Stop using that word. I don't think it means what you think it means. I have yet to see anything simple from you. Okay. Then again, Clayton's efforts to expand the case may have been a gold mine for YouTubers, making sweet super chat cheddar off each new video. Well,
Do you get sweet super chat cheddar?
no, I don't.
Okay.
No. I don't think okay, all right. I mean, people do make money off of these, but also it is nowhere near as much as you think. YouTube takes 30% of everything, but okay, David. Okay, sound off.
Well, he would know that if he wasn't kicked off YouTube.
The shade.
Allegedly.
Allegedly. I know that's definitely what happened. Legally, throwing so much irrelevant dirt out there was a big, big tactical mistake, in my personal opinion. Yeah, for your client, it was a mistake that all happened. But they did it, David. They did it. My rule, if a David, My rule, if a story requires more than 10 to 15 seconds to present, you risk losing your audience. Always keep it simple. It's been 15 seconds, David, but okay.
Somebody's been studying how to make YouTube videos.
Right? Go back to basics. That is more or less the approach I tried to use today. And for the record, I had about 100 pages of questions ready for everyone who did not testify, which I promptly threw out the window once the judge made it clear how little time we had. It didn't look like there were windows in there, but
Well,
okay.
it's easy to make that claim when you never had to present it in the first place.
Right. I'm
Probably
Mary the
didn't.
Cool Cat. Hope you're doing well today. The hypocrisy is unbelievable. He does not follow his own rule. He cares a lot about the rules, except for the keep it simple rule. That one.
He only cares as they apply to other people.
There's Amos, our Lego queen. We did a what did they call it?
A shout out, pimp.
Disingenuous coronation over the
Oh,
weekend. And
we did.
crowned
Okay.
Amos the
I
Lego
was going in a completely different
Okay.
direction than you are with that. I was like, we were pimping you out, your services. Like, she's like, no, we made her a queen. I'm like, oh, yeah.
Okay. I guess that's better than pimping. What? Okay. Anyway, so 3.3. As a lawyer who has done this for 20 plus years, my view is Laura is an outstanding witness. Sir. Well, you know what? She was outstanding. I've never quite seen somebody like that on the stand before. So, okay. Outstanding is a word for it. Given the
So
pressure
was she outstanding before or after the panic attack on the stand?
I don't know. Both. Marvelous. Given the pressure she was under, I couldn't have asked her to do any better. David. Yes. Yes, you could have. You could have told her not to lie on the stand. That's what you could have done, David. You had probably objected. Been like, by the way, girl, plead the fifth. All right. Just objection, Your Honor. We're not answering that.
I
Yes.
mean, didn't she ask her if she wanted to confer with her attorney before answering the question? She's like, no, I know how to answer questions.
Yes. I know how to answer questions. Yes or no. Well, I not like that though. Yes, the audience chuckled. GFY. What does that mean? Go fuck yourself? What does GFY stand for?
It does mean go fuck yourself.
Well,
Or it's a code for an airport. It's one of the two.
it says
pretty sure it's
GFY.com. I don't know what that means, but we're going to go with go fuck yourself.
Can we click it? Can it take
I
us
tried.
anywhere?
It didn't take me anywhere. It was like a
I'm
death
pretty
link.
sure I'm actually joking about the
Oh,
airline code.
It's,
I'm
yeah, I
pretty sure
don't.
it's go fuck yourself.
Yes, the audience chuckled. Go fuck yourself. Seriously, hurt Laura. But I am beyond proud of Laura for what she did today. Okay. All right. All right. So, lawyers usually have to stand up. If there was a press release afterwards, he would have said the same thing. Is that actually what happened? No. But, sir, yikes. Okay. For my number one thing is that I always, always, always want to get to the truth. Woodnick and Deandra clearly don't share that view. This is just my personal opinion, but I feel they couldn't care less about the truth, and that's a shame. What? All right, you've only got me on one of these, David. We
I
watched the
think
same thing.
it's so cute. He's using his I feel statements. He learned that in therapy, right? No, I'm just kidding.
That's right, Goose Block. Who got guard geese after Llama learns about yesterday? Just saying, you gotta get those guard geese army. We learned about it. Did you know that guard geese? They are very good at being guards. As a matter of fact, a distillery in Scotland used them as their security geese. Guard geese. The more you know about, you're muted. The more you know. So
I said interesting.
It was interesting. There's also guard llamas too, but they're not as good as guard geese. So anyway, number 5, this really isn't the time or place to air all my grievances because I said I was going to keep it simple and to the point, but I'm not. But let me give you one example of conduct that I feel is way across the line. Laura admitted that when she got the 102 HCG test from October 16th, she knew it was bad news because it meant the pregnancy was in the process of ending. If it hadn't already, it's impossible to know for sure. She could have literally gotten an ultrasound that day, but okay. In a moment of panic, she doctored the test to change the reading to 130,000 or whatever. And she sent that to Mr. Neal because she thought it might shut him up or just who cares? David, how are you justifying this to where, you know what? She thought she was losing the baby. So she panicked and did this and was worried about a fucking YouTuber instead of allegedly losing these alleged twin babies. Make that make sense, David. I would not give a fuck what somebody on YouTube was saying if I thought I was losing my babies. I can tell you that. And I'm pretty sure I can speak for a lot of the people in chat that have been through it too. No, I don't care. Hi, Echoes. You're up and not awake. Join the club. Good, sir. Join the club. That's true. Llamas do spit and bite. Let's see. Everyone slams Laura for doing this. It's stupid, but not me. I compare it to this story from earlier this year where Princess Kate, oh, geez. He loves name dropping people in his articles that are not relevant to this whatsoever.
The royal family has entered the chat.
Mm-hmm. Cool. Did not have them on my bingo card. Okay, David. I compare it to this story from earlier this year where Princess Kate Middleton released a Photoshop image of her family after she had mysteriously dropped out of public view. She went missing because she was diagnosed with cancer, and she released a doctored photo as a way of trying to distance from that. The ruse worked for about 2 seconds before she was called out. Okay, but those aren't the same, though, David. They're not the same. She wasn't in a court case. She wasn't pretending to, I don't know, have babies, which
She's a princess.
she's a fucking princess. All right. I know you think Lori's a horsey. Lori. Laura is a horsey princess, but these are not the same. These are not the same to me whatsoever. Laura's 130,000 or whatever HCG test was done for a similar purpose. Laura only sent that to folks like Dave Neal. She never used it in court, and she didn't fake the document for any malicious or nefarious purpose. You just said it was to shut somebody up, and then if it's fake, make them give fake news to the public. How is that not nefarious? What is your definition of nefarious, David? What is it? I know he's not doing these things anymore, but still, what is it?
Not following Rule 26 is nefarious. Nefarious.
She was just trying to regain some privacy by putting out fake info. And yes, it was a dumb way to do it. Seriously, Kate Middleton has a huge PR machine behind her, and she made the same mistake. Different, but the same. Did he make this argument to Laura? And she was like, I too am like a royal princess, David. You're right. I am just like Kate. Oh my gosh. Yeah, I was gonna say she got a bunch of shit from it, but also like she actually did have something going on. She had cancer. Laura has literally nothing going on. She's not pregnant. We all fucking know that. But these are not the same things. Llama is an unusual name. The only person you know is the Dalai Lama. Well, my online name was not a drama llama, and that's what everybody knew me as. And so then it just got shortened to Llama, and now I'm still Llama because that's what everybody knows me by now. So it sticks. It's fine. I like it. And I'm a good defender according to guard llamas. So watch out. Oh, wait, hold on. My point is that Deandra dishonestly, in my opinion, tried to misrepresent the facts by claiming that Laura doctored the 130,000 or whatever HCG test twice. No, Deandra, she did not, and you know that. Did she mention it twice? I don't know. I'll have to watch it again. What happened is that when Deandra first asked Laura about the test, which originally said 102 on the genuine document, Laura said she changed it to something much higher. And she threw out a figure like 102, 102,000, which makes sense. Deandra then showed her the actual fake document, which clearly said a different number, 131,902, which is a very weird, distinct number to pick, but okay. Anyone who is following along understands exactly what happened. When Laura was asked to describe the fake version of the document, she didn't have it in front of her. Wasn't it on the screen? I'm pretty sure it was on the screen, but okay. Based on her memory, she admitted changing it to a much higher number, which is true. Laura said something like, oh, I already read that. I'm sorry. Duh. Did Laura lie? Perjury? No. Well, maybe not at that one, but she got some other charges, David. Okay.
Write that down.
Mm.
It's almost like they predict the future
I think
in their
right.
blogs.
Right. Laura simply didn't remember the exact figure. Why would she? With everything else running through her mind. Okay, David. I've never seen a lawyer bat this hard for their client, though.
I feel like this is going to be a preview to her defense.
Right. Oh, that's fair. If you're a liar, and Lola's a liar through and through. Oh my goodness. Deandra tried to twist the minor slip of memory, minor again, just a minor slip of memory, just a minor perjury, just a minor misstatement, just minor, guys. Deanna tried to twist that minor slip of memory to make it look like Laura created two versions of the fake document. One that said 102,000 and one that said 131,902. Deandra must have repeated the dramatic point 3, 4, maybe 5 times. It was so dramatic. How do you not know the number, David? But Deandra knew there were not two different versions of the document. She knew that for a fact. She knew this because there is no version that says 102,000. If you have one, show it to me and I'll apologize and buy you nachos. And then we'll go to Topgolf and we'll have a beer. I could have swore I've seen it.
He buys a lot of nachos for people
He
or
does.
offers to.
I swear we've seen a document that said 102,000.
No,
in
I
our
think we saw
covering
a
this.
document that said 102.
Oh,
I don't remember seeing
102,000.
102,000.
Rings a bell, but I don't know why. We've seen so much bullshit, it's hard to say. Maybe in Deandra's mind, trying to take advantage of a small mistake like this is fair game. It is. You're in court, David. That's literally your job, is to find little things, little mistakes here and there to either help your client, get your argument across. But okay. I don't agree at all. In my view, it's dishonest. It's trying to present a false impression that you know is false. But the truth is, ethically compromised lawyers are part of this profession, which is exactly why I refuse to walk away from this line of work. Okay. Because I want to do everything I can to help bring the truth to light, even if, and especially because, there are people like Deandra and Greg out there trying to do the exact opposite. Sir, stop. No. Oh my gosh, he is anything. Why would you have to fake anything? Exactly. Hi, South Florida thrifter. Hi. Good morning to you. People singing minor perjury in chat. Oh gosh, this guy. Say cheese. Says, I think David was unprepared for this hearing. He didn't go over her prior testimony in the protective order hearings. It was before his time, say cheese. Before his time. What is he supposed to do? How else is he supposed to write 100-page documents every other day?
Are you supposed to read all the stuff in the file?
All of it, though? I don't think so.
All of
No.
it? Who has that kind of time?
Hi, Wallace. I know, right? Wild. 6. Dr. Medchill had a lot more to say, but due to the time constraints, we had to limit his comments to only the stuff that mattered. And at the end of the day, Dr. Medchill told me over and over and over his view and exactly what he said. Laura was pregnant, no question. She got pregnant and the pregnancy failed pretty early on. We can't know exactly when because she never bothered to fucking go see a doctor or go to the hospital. But every single data point we have lines up with that narrative. It's one narrative, but okay. The only data points that don't line up are things that we don't know are genuine, like the 131,902 HCG reading. The PP sonogram isn't part of that analysis because, as we all know, it can't be verified. So we just don't consider it because my client also fucked that up too. The one ultrasound she alleged to have that, oh, that's right. Didn't she catch some charges for stuff like that? Mm.
Yeah, I don't think he's helping her out at all with this blog. No,
No.
sir.
No. But as for the objective facts, we do know are genuine. They all support Laura's story. All of them. Literally every single one.
Mm.
Okay. Why does no one agree with you, though, David? I mean, that has to. Literally nobody, but that's all right. I forgot. At this point in time, David thinks everybody, all of you, are fucking idiots. Okay. So let's not forget. He thinks we're all fucking idiots. I feel my IQ points dropping.
We're sorry.
I know. Us too.
We didn't write it. We're just reading it.
7. Dr. Medchill had no bias in this case. He never met Laura or her family prior to this case, and he wasn't doing anyone a favor. He was not a friend of Laura's family or anything like that. He was paid for his time, and we disclosed every detail of this to Woodnick without him even asking for it because transparency is important. It is, David, but your client doesn't know how to do that, but okay. 8. At the end of the day, I am not going to make any predictions about how the court will rule. Once we get the ruling, I might offer some views about it, or I might not. He definitely is going to, because he always does, David. You always write like 3 of these a day. It's wild. I've said this before, and I'll say it again. If I believe the court made a decision that's legally incorrect, we will pursue an appeal. But because I don't know what the judge is going to do, I'm not going to speculate about what the future looks like. Well, it's your right to appeal it. It's not like some thing. 9. Yes, Laura was upset when the audience laughed at her. I can't believe how strong Laura was to sit there with a courtroom full of people just projecting hate, hate, hate towards her. Oh, you guys in the chat that were there, how dare you? Just kidding. You guys weren't anything like that. I mean, again, Laura, you've done it to yourself, babe, by all the bullshit you posted online, all the lies you told. Guess what? Oh, well. Laura is such a good person. She just has been so unfairly portrayed in all of this. I've gotten to know Laura extremely well over the last 2.5 months, and she is nothing like what people think. I also don't think today was the cakewalk Clayton expected. When the trial ended, Clayton sat at his table looking like he was about to cry. He didn't. Or it could just be because he's glad it fucking finally happened. And there were lots of people there to support him. Maybe it was actually like a beautiful moment, David. Did you ever think about that? On my way out the door, I did wish him well, and he returned the comment. The fact is that trials are emotionally brutal for all parties. That is very true. That's why it's called a trial, because the experience is extremely difficult, aka trying for everyone. Yet somehow your client seems to thrive by filing court stuff all of the time. Makes no sense. 10. Oh, God, there's so many points. I didn't have an opportunity to make a closing argument. So I'll end this post with a few final thoughts because I said I was going to keep it short and simple. 10 to 15 seconds. Oh, boy.
I was about to say, I doubt it. Seriously.
Legal issues and arguments aside, my personal view is that both Clayton and Laura need to learn from this, move on to become better people. Both of them. Actually, you know what? I do feel like Clayton's moved on, and I do feel like he's probably a better person from like the growth he does. That doesn't make him a bad person before, but he has learned stuff. You know who hasn't learned anything? Your fucking client, Laura. That's who. Still doing dumb shit. But okay. Both of them made mistakes. Both of them did things they shouldn't have. Both of them need to remember to err is human, to forgive is divine. Your client cannot forgive anybody of anything. Are you? You've read the messages, David. Come on. So, kids, stop fighting.
OMG.
Your client is the one who keeps bringing stuff to court. Oh my God. Oh my God. You don't have to kiss and make up, but Jesus, can't you just let this go? And that's
Who are
mostly
you
a
talking
question.
to is what I'm questioning.
Oh,
Okay, well,
he's going to tell you. He's going to tell you. That's mostly a question for Clayton, since Laura tried to let this go 6 months ago.
Not before, like, driving him mad forever. Like,
Right.
what?
Mm-hmm. Oh, there's a little ducky. Hey, babes. Hope you're doing well today. Happy to see you here. I know. Has anyone told Lo that? Unbelievable. Clayton and Laura are still both young. Laura, like any woman would, wants to have a family. She wants to be loved and she wants to be happy. And I'm sure Clayton does too. We outsiders should not be focused on how to destroy either of them. We should focus on how we can help lift them both up, guiding them to be better people. No person is beyond salvation. Don't care what they did yesterday. The question is, what will they do tomorrow? You know, I wonder if David thought that maybe she might end things, just walking away. But David, here we are, 2 years later, doing the same thing. At the end of the day, as everyone knows, I am a seriously imperfect person. That is true. We all are. All sorts of mistakes, many of which were way worse than anything Laura or Clayton did here. Okay. But I learned from my mistakes. I owned them. I still own them. And I've grown and moved on. And I'm proud of that fact. One of the most powerful things any human can do is to accept your flaws, Don't fear them, use them. Use your mistakes as a ladder you can climb up, not as an anchor that defines you and ties you to your past mistakes. Make a mistake, own it, get up, dust yourself off, apologize and mean it, then move on and don't do it again. Oh,
Is he trying to get his own TED Talk?
I think so. Once this case is finally closed, the debate about whether justice was served will always linger. A court can rule that Laura was never pregnant, just like a court can say O.J. Simpson didn't murder his wife. Oh, okay.
Ooh. We have Kate Middleton and O.J. Simpson. All right.
Okay. Courts are funny like that. Everyone in the legal system tries their best to find the truth. Well, most of us do. In the end, sometimes we succeed and sometimes we fail, but we always keep trying.
And I'm proud to be an American. I'm sorry. That's what I just felt like he was getting all preachy.
Wild. Also, You changed your wait, that's Nicholas. Nicholas says, and we keep blaming Clayton because why? Exactly. Exactly. Mary changed her name to Mimi. Okay. Well, we like it, Mimi. That's fine. We're fine with that. But you can't change your picture and your name at the same time, or I won't remember. Change one at a time, and I'll be able to keep track of who you are. You do both, it's going to be hard. What did he say? Elvis says, what did he say at the beginning of this post about taking too long to make a point? Yeah. Yeah. Rob says, does anyone think I should reach out and see if he'll take my future cases and stand up for me on my behalf when he's the one that was
If you
opposing
do, you
counsel?
should use it as content.
That's true, Deb. This is very true. Too many people believe that if they say it, then it's true. That's not how it works. Or when they're like, my feelings are, no, your feelings aren't always true. Okay. They're just not. Sometimes your feelings are also wrong about what happened because you interpreted things wrong. But oh my gosh, it's so annoying when people are like that.
But it's my truth.
Right. Well, your truth can also be wrong. So there's that. I don't know. Like Laura's truth is her truth. Is it the truth? No.
But
No,
it's
it's
mine.
not.
It's my truth.
That's fine. You can own it. You can own it. But no, thank you. Anyway, so that is that one. You sent a pic in the courtyard of Bond watching you queens. Oh, shut up. Is Bond a fan too? I love this one. I'm going right over to look at it. I love when people send us pictures of their animals watching us, or sometimes they're small babies. It's fine. They don't understand what we're saying. We're just their aunties. Oh my gosh, that's cute. He is watching us, you guys. Oh, that's so adorable. Hi, Bond. James Bond. Cute little kitty. He is front and center. That's amazing. Oh, all right. So, of course, Bond's a fan. I love it. He's the one that really wants to be a star, Hellville. I'm telling you. I'm telling you. All right. So up next on our list, I'm gonna let this play where I go to the bathroom and stuff. So I'm not gonna pause it while it plays. I'm gonna use this as my opportunity to listen and go pee. But up next, we have Laura's call. So this is the next day, June 11th. And we got Laura's phone call to the cops, thanks to Schnitzel Ninja.
Schnitzel Ninja.
She has all the phone calls, videos, court hearings, all of that over on her channel. So go give her a sub. Like this video. You're welcome, Amy. I liked it for you. And it's on Amy's new account. She has all of them liked on her other account. So now I just go through and re-like everything for her. And so we will give this a listen to see what she has to call the cops about this time. They're so scary. Anyway, okay.
Hi, I'm calling to report violations of multiple restraining orders.
Okay. What was the address that this took place at?
It actually took place online.
Okay. Do you have a
one of
Scottsdale
them,
address?
yeah, I do. And one of them actually was at the Northeast Courthouse. So do you want that address or do you want mine?
We'll just go with yours and then I'll have the information. What's your address? And what is your name?
Laura Owens.
And what's a good telephone number for you? Okay. And how long ago did this take place?
Yesterday and the day before yesterday.
And who was it that you have the order against?
So I have the order against, I have an order against 2 men in Arizona and 1 in California. They were all together and kind of coordinated. It's kind of complicated. Do you want the men's names?
Yeah, if I could get them.
Yeah, absolutely. So it's the first one is Gregory Gillespie.
Please spell the last name.
Gillespie.
Do you have his date of birth by chance?
Let me see. I have the order, so I'm guessing that has it on it.
Okay, and the second subject?
Clayton, and the last name is Echard.
Do you have that date of birth? Okay. And their order of protections that you have against them?
Yes, I have orders of protection against those two.
Okay. All right, Laura, what I'm going to do is have an officer give you a call to talk to
Oh,
you.
and then there's one more.
Oh, there's
one. I'm sorry about that.
That's okay.
The other one's actually, yeah, it's a California order. I got the order in California and moved to Arizona, but I was told by San Francisco police to contact you guys.
Mhm.
So that man's name is Michael, and then I can spell the last name. It's Marracini.
Okay. And what's Michael's date of birth?
This is wild. So embarrassing.
Okay, what I'm going to do is have an officer, like I said, give you a call to talk to you about making a report. It may show up as a blocked or restricted number when they call you, so just for the time being, make sure you answer any phone calls you receive until you hear from us, okay?
Okay, sounds good. Thank you so much.
You're welcome. You have a good rest of your day.
Okay, you too. Bye.
Bye-bye.
Like, what? Girl, are you serious right now?
So the phone call is about them showing up in court or posting a picture online?
Both. All of the above. All of the above. How dare they? How dare they show up?
Did the restraining order prohibit them from being together or just around her?
They're conspiring, though, Buffy. I don't know. It's so stupid. I can't even believe you would call the cops like that. Like, are you serious? The day after, too. Grow up, Laura. This is why people don't like you, because you do dumb shit like this that is stupid. And you're wasting.
Wow.
Somebody just put like the wasting resources. Where is it at? There it is. LMP. The fact that you waste resources like this, grow the fuck up, Laura. Oh my God. I can't even with you. They hurt my feelings, guys, and the internet was scary. I don't like it. So weird. All of her
You could
papers and
hear
notes.
how terrified she was. She was practically, her voice was quivering. She was, sounded like she was in a corner rocking back and forth crying. I mean, it sounded like sheer terror, and my heart goes out to her.
Well, and I like how she left details out for the 911 caller that she saw them at court first and foremost, and then the others on the internet. Like, are you serious? It's ridiculous. Yeah, Buffy, couldn't you hear the fear Deb says? Well, don't worry. We got the police report to pair up with it. So let's see what Laura tells the
goody.
cops.
The
Shall
cops are like, I don't know why I'm here. This bitch be crazy, allegedly. In my
Allegedly.
opinion.
So let's read the police report. So on June 11th, 2024, Laura Owens claimed Clayton, Mike, and Greg all violated her active orders of protection against them. The incidences occurred on multiple occasions as detailed in the report and attached documents. They're wearing a police designated police uniform and on-body camera and driving a fully marked. Where's the camera? Do we have these cameras? They're not on my list. I know. I know people have reached out for all of these. Some of them they still haven't gotten, which is interesting.
Very interesting.
They applied for them, but Let's see. So, interview with Laura. I then called the reporting party, who identified herself to me verbally as Laura Owens. I asked Laura to explain to me what happened, and the following is what she told me, and I rolled my eyes so hard. She explained that on June 10th, 2024, three different men whom she has order of protections against all came to town to conspire against her and create a smear campaign. Oh, didn't her mom just say that in bankruptcy court the other day?
A smear campaign.
Smear campaign.
That's a buzzword.
She stated that she was in court on the 10th and that Michael Maricini violated her order of protection by appearing as a witness in a court hearing where he was asked to testify as a witness. She stated that the judge that presided over the hearing knew about the order of protection and allowed Michael to testify and stay in the courtroom. She stated that her attorney told her that this posed a significant threat to her safety and well being, and that it violated the strict no contact rule in the order. To quote her further, quote, Judge Mata allowed Michael Maricini to stay despite my restraining order, stating judicial branch security will ensure the safety of all parties while at the Northeast facility. Additional accommodations will be considered as requested. This statement does not justify the violation of my protection order. Oh, she goes on to say more? I don't know. This statement does not justify the violation of my protection order, as the presence of court security does not replace the legal protections granted by the restraining order. Oh, she said that. She stated that the hearing was related to a paternity case against Clayton Echard, whom she also had an order of protection against and is also guilty of violating her protection order. Because remember, she has an injunction against harassment, or he has one against her. So make that make sense, Laura. Laura then sent me an email detailing, oh God, that's probably like 18 pages. Laura sent me an email detailing how Clayton and Greg, she also has an order of protection against Greg, have violated her orders of protection by indirectly causing their substantial following on social media to harass her. She states that Clayton has appeared on multiple podcasts saying that Laura, she is dangerous. And she needs to be prosecuted. It should be noted that she could not cite an instance where any of the three males asked their followers to harass her. So thank goodness this cop is not falling for it. Laura states that Greg violated her order by posting, "Stop this woman. No one should cave to her harassment. She is dangerous." Laura stated that these posts and comments on podcasts are violations because these statements are untrue and defamatory in nature, and they incite their followers to further harass her. Laura, then, just because we all see it, Laura, okay, just because you don't realize how dangerous you are does not make you not dangerous. We all see how dangerous you are. And that's why people are trying to get you to stop before it gets worse. Laura, because you're playing with fire a lot of times, girl. Laura stated that these posts and comments on, I already said that. I'm sorry. Laura then cites that one of the orders of protections, defendant shall not communicate or post untrue or harassing comments regarding plaintiff online, including, but not limited to, on social media, and shall not cause others to communicate or post untrue or harassing comments regarding Laura online or otherwise. Echard's claim. Laura claims that Clayton violated her order by stating on podcasts she is dangerous and she needs to be prosecuted. I mean, she didn't like it, doesn't make it not true. The details are listed above and stating an opinion about a court case, and her on a public platform does not violate the order. The Gillespie claim. Laura claims that Greg violated her order by posting, "Stop this woman. No one should cave to her harassment. She is dangerous." It should be noted that these opinions were posted on a public platform, and nowhere in the post does it incite his following to harass her, nor is it direct communication with the plaintiff. The Maricini claim. Laura claims that Michael violated her order against her by attending a court hearing where he was summoned as a witness to testify. To quote Laura and the judge who presided over the case, Judge Mata allowed Michael Maricini to stay despite my restraining order, stating judicial branch security will ensure the safety of all parties while at the Northeast facility. Additional accommodations will be considered as request. Laura claims that a standing Maricopa County judge assisted in violating the order along with Michael. Now who's doing the conspiracies? Am I right? Further, it should be noted that Laura sent me an email outlining all the instances where all three of the orders were violated, all of which are tied to comments made on public platforms. Laura also attached the valid and active orders against the three men. All the documents and the email will be attached in the report. There is no clear violation of any of the court orders. The email. Okay. Here's her email, guys. The email. Hi, officer. So I apologize for any confusion during our phone conversation and appreciate your attention to this urgent matter. Since I have had to renew the restraining orders against Michael Maricini and Greg Gillespie before, I am familiar with the process and how important it is to report any violation. You do know why that's important to bolster your case, even if you make them up, allegedly. So, oh, hi, Polly. Thanks. Happy memberversary. 13 months, a year and 1 month. Love your daily coverage on this amazing work. Thanks, Polly. You're amazing. I love you. Thanks for joining.
That's my wife.
That's my wife. This is their vendetta against me. Oh, I'm sorry. Yes, they're coming. Oh, I skipped that whole paragraph. My apologies. As you can tell from the video, I am attaching the three men I have the restraining orders against, Clayton, Michael, and Greg, are coming together to try to paint me as the abuser because I have orders against them. This is their vendetta against me. In the past, I have not pushed hard for prosecution, but given their coordinated efforts to harass me themselves, as well as incite harassment against me on Clayton's platform, his Instagram has 295,000 followers. I would like that to happen now. She wants them arrested for what, Laura? For what, though? Right.
For
freedom of
saying
speech.
mean words.
I don't like it. Peachy. Laura, when talking to the courts, I'm afraid of the people on the computers, in the computer.
You can't just use the courts to shut people up.
Nope. She keeps trying and keeps trying and keeps trying. In the past, I have not. Oh, wait, I already read that. Sorry. I am attaching detailed accounts of how Clayton and Michael have violated the order. For Greg, I wanted to report that he has engaged with a Michael Maricini on one of Clayton's posts on social media, calling me dangerous, despite the fact that I have never committed a crime. Girl, what? Yet, yet in the storyline, but also there's a lot of dangerous people who have never been caught for crimes. So that doesn't.
I was
make
about
any
to
sense.
say. Also, I mean, define crime. Define crime.
Right?
Because everybody's
Official
committed
charge.
at least one crime in their life. They just
Yeah.
never got in trouble for it.
She's never got in trouble for it. But she's never committed a crime, you guys. And hold on. I'll say this after I get done with her little rest here. This is by the shortest thing she's ever written, ever, that we've read. Additionally, Greg appeared in the video I referenced above, further violating the order by causing others to harass me indirectly. Given the gravity of these violations and the ongoing harassment, I urgently request that appropriate action be taken against Greg, Clayton, and Mike for their clear and deliberate breaches of the restraining orders. I know this is confusing, but I can be reached anytime for questions because I don't have a job or anything. Thank you. All the best. She actually signs it all the best. NFI, which I don't know what that means, but okay. So what's interesting is she hates when people call her dangerous. It's maybe she doesn't think she is. Honestly, it's really surprising that nobody's lost their life yet in the process of everything we've covered. Thank goodness nobody has. But it's alarming, right? But when somebody she says, "I've never committed a crime." Well, we know we haven't watched the body cam videos, but I know the quote from that. It's not like I murdered anybody. I just got pregnant by the fucking bachelor. And then we also know she goes on to say that she is a non-violent autistic woman. The fact you have to constantly keep talking about how you didn't commit a crime, you're not violent. People don't say that. You know what kind of people say that? People that have a hard time managing their emotions. So I don't know. I don't know about all of that.
I think she's just downplaying. She doesn't think it's not as serious. What she's done or whatever is not as bad as. Like,
Mhm.
it's not as bad. It's not like I killed anyone. It's just
Right.
minor compared to that. But like, it doesn't make it not a crime.
Exactly. And she gets 14 felonies after this. Oh
Not a
man, yep.
race to the bottom, Laura.
Right? The IRS may have an opinion on that eventually. I thought I saw Tiff. Oh, there she is. Hi, Tiff. Good morning. I hope you're doing well. Oh, good point, Tiff. Using that logic, none of these men have ever committed crimes either. Exactly. But
It's not a criminal crime.
it's not a as Ben says, it's not a criminal crime. Oh, she is exhausting. Well, as we see, this officer's not fucking buying it. You're like, what? Okay, weird. This is all rando stuff about each person. It's not that big of a deal. How they're all related. Oh, so here's some attachments. Oh, this is Greg's post on Insta. Stop this woman. No one should cave to her harassment. She is dangerous. Who's that? Is that Mike? I think that might be Mike. Dangerous is an understatement. Actually, no, I don't think that's him. I don't know who that is. But I got lots of hearts. All right. So then the next one, wait, when does the judge thing come out? The 18th. So then the police do another report on June 16th. So here's this update on the 16th. On June 16, 2024, I was made aware that Laura had sent more evidence of further violations of the court orders. One of the documents that was sent to me was an email that Greg sent to Laura's attorney stating, "Hey, loser, glad it didn't go your way, like in any way possible. LMAO, enjoy your trip. You know, I think a new city for you might be a good idea." But is this
That's
her lawyer?
hilarious.
How's sending it to her lawyer a violation of anything? If he did, in fact, send it. I don't know if he did. or
Okay,
not.
but that's hilarious if he did.
Right? I mean, it's some solid advice. You probably should have taken it. Laura herself stated, "While this email was not sent directly to me, it is about me and contributes to the pattern of harassment and intimidation." Shut up, Laura. Shut up. It should be noted that the order of protection does not include Laura's attorney as a protected party.
I was gonna say, I think your lawyer is a big boy. And he can
Right.
handle it himself.
Oh my gosh, it's unbelievable. There is RJ says, "Laura is special. She is so above committing crime. This is all a conspiracy against her. After all, everyone lies in court. It's no big deal. Why should she not be held accountable?" I know, right? Oh gosh. Unbelievable. Am I right? All right. Additionally, Laura cites comments that Gregory made on Instagram saying, "It takes a village. Way to hang in fight. Monday was a good day." Oh, the horror of that sentence. Are you not just scared and offended by what he just said there. It takes a village. Way to hang in and fight. Monday was a good day. Oh my
Fight.
goodness.
That was the triggering word. That's where
And
the violence came in.
P.S. Watch out for the JD curse. You could be a father in 36 months. That's the Jane Doe curse. And thank you. Yeah, it's nicer having the truth out in the open and a community that has your back. That's what it takes to be a criminal like her. And finally, well, he's not wrong. She does end up being one. Pretty soon, you know who will be named publicly. When that day comes, let's keep an eye out so that no one else joins this fraternity. Pretty soon, you know who will be named publicly. Her? Probably Jane Doe. I think they were still calling her that at the time, like online and stuff. It should be noted that none of these comments include Laura's name. None of them show Gregory asking people to harass Laura, and all of them are opinions made on a public platform. Based on the new information given by Laura, it still stands that there has been no clear violation of the court orders. But why aren't the police listening? They must be JFC. They must be part of the JFC cult. All the police. Okay. So there's that one. And then okay, yeah, that's like it apparently for that. I thought you had 7 and 8 marked for something else. That's weird. All right. So that leaves us with our final thing to go over today, and that is Judge Mata's final ruling under this. Oh my God, who's excited? I'm excited. So this is 2 days later on June 18th, about, how many days? 8 days after the trial. Which if you've ever been in these kind of courts, they do take a while. Actually, this is pretty quick. My friend who went for a DVRO and it took her like a month to get the ruling back. It was very annoying and stupid. But you might want to pull this one up, Buff, because I think I might have you read some parts of it. Just have it up in the meantime, just in case. So let's go with this is our under advisement ruling. Jurisdictional findings. The court finds at the time this action was commenced, at least one of the parties was domiciled in the state of Arizona, and that said domicile has been maintained for at least 90 days prior to filing the petition. There are no minor children common to the parties. So Laura's lived in Arizona for at least 90 days. Okay. Procedural history. Oh, bullet points. Okay, I appreciate that. Laura Owens, petitioner, filed a pro per petition to establish paternity, legal decision making, parenting time, and child support on May 20th, 2023. No, that's not correct, Your Honor. She filed that August 1st. May 20th was BJ Day. But okay. Petitioner filed, I don't understand how. Okay. Petitioner filed a pro per motion to communicate on August 23rd, 2023, a motion to compel on August 29th, 2023, and expedited consideration requested, motion to communicate filed September 14th, and expedited motion to seal court record on September 14th, 2023. All motions were denied. Clayton Echard, oh, jeez, sanctions on the judge. Oh, if David has his way, that's for sure. Hello, Jen. Thank you for subbing. Appreciate you joining the group. Make room on the couch for Jen Pookie, another person with cute little dogs in their picture, which I love. So welcome. Yeah, I don't know how she messes up the first line, but okay. All right. Let's see. Clayton Echard, the respondent, filed a pro per answer on August 21st, 2023. The court granted Clayton's motion for leave to amend response filed by counsel. All right, this is all stuff they sent there. None of this is important. This is the timeline of orders, and it's fine. We don't really need to go all through all of that. Let's go pick up here on October 18th. On October 18th, Laura filed a request for pre-decree mediation, citing Clayton's unwillingness to communicate with Laura and citing he even acts as if the unborn children don't exist, despite a preponderance of the evidence, which the 18th is the same day she gets that HCG, or is it the 16th? On October 24th, the parties appeared before Commissioner Judge G, retired, in response to the injunction against harassment filed by Clayton. On the parties' stipulation, the court previously reviewed both days of the hearing and identified that Laura, appearing virtually, frequently stood up and rubbed what appeared to be a swollen abdomen. November 2nd, 2023, testimony resumed, and Laura testified that she was 100% and 24 weeks pregnant with Clayton's children. She further testified that the twins were due on February 14th, 2024. She further testified that due to epilepsy, she was experiencing a high-risk pregnancy and was being cared for by two specialists named Dr. McCool and Dr. Higley. She testified she last saw Dr. Higley last Friday prior to the November 2nd, 2023 hearing. Then, October 25th, the parties appeared before Commissioner Duty to determine the validity of the contested OOP. Laura's abdomen again appeared swollen. Despite this hearing, she testified to the validity of the sonogram sent to Clayton, the media, and a Dropbox on Reddit, and further testified the parties were having a son. She later testified she believes she was having fraternal twins, one boy and one girl. She is special. All right, I'm going to read this part and then I'll have you read the findings of facts, if you don't mind. Buffy, I had to remember your name for a second. Oh my gosh.
How did you forget me?
Because I am so, that's why I'm having a late week this week, because my brain is just so exhausted. So exhausted.
Can't imagine
So
why.
I can't imagine why. Can't imagine. Hi, Teresa. Welcome. Oh, Raz and Taz is back. Hello and welcome. Happy to see you here again. I kind of feel bad for Judge Duty. Yeah. Well, it's Duty, Doody, which is
It's even worse than duty. It's duty.
Right? Duty. All right. So then December 6, 2023, a second Ravgen test confirmed little to no fetal DNA. A third test was done, however. The results were lost in transit. That was the second. Okay, whatever. December 12th, Clayton filed a notice of filing affidavit for non-paternity. December 28th, 2023, petitioner filed a motion to dismiss petition to establish paternity, all of that other stuff. Laura cited the basis for the dismissal was she is now not pregnant with Clayton's children. The motion was denied as the issue of attorney's fees, costs, and sanctions remained. January 2nd, 2024, Laura filed an expedited motion to quash deposition of herself because she didn't want to fucking do that. January 3rd, Clayton filed a response objection to her motion to dismiss. The court denied Laura's motion to quash. Clayton withdrew his motion for sanctions pursuant to Rule 26. Hopefully that's the one drink we have to do today. On January 3rd, 2024. Laura filed a motion for, okay, this is all just stuff she filed. Skip. Let's see. At a status conference on February 21st, Laura was ordered by this court to comply with Rule 49 disclosure agreements. During the hearing, Laura's counsel advised that Laura had miscarried sometime in September or October 2023. Laura was deposed on March 1st. On June 3rd, Laura's prior counsel filed Ethical Rule 3.3 Notice of Candor, wherein counsel advises the court the statements made by counsel at the February 21st, 2024 status conference were factually incorrect. Specifically, counsel stated Ms. Owens has not lied in this case. She has not intentionally lied to the court. Yeah, when your lawyer has to go tell the court that, ooh, it's not good. Not good. While counsel believed the statements to be accurate at the time, counsel later determined those statements were not true based on Laura's deposition taken March 1st, 2024.
The lie detector
Voluminous.
determined that was a lie.
right? Everybody's new favorite word the last couple days. Voluminous additional pretrial pleadings were filed by both parties. Those motions were ruled on separately by minute entry, and the rulings are not relevant for purpose of this hearing. So you are going to do findings of facts by the judge for Laura. And I'm going to be right back.
All right, guys. Suffer with me. No, I'm just kidding. Okay, so petitioner contacted respondent through LinkedIn. Laura and Clayton met on May 17th, 2023 to locate potential investment properties in Scottsdale. Laura has a podcast, a real estate investing company, and buys and sells horses. Between May 18th and 20th, the parties viewed some properties in Scottsdale. And on the evening of May 20th, 2023, Clayton invited Laura over to his home, which she accepted. And after Laura arrived, Clayton told her he was high on cannabis gummies, and he offered one to her, which she accepted. During the late evening of May 20th, 2023, and early morning of May 21st, both parties agreed that petitioner performed oral sex. Laura performed oral sex on Clayton to completion, in quotes, twice. Laura testified she did not want to have sexual intercourse. It's always me. It's always me that reads this part. Always. Laura testified she did not want to have sexual intercourse, but that Clayton stuck it in briefly. Laura's implication that Clayton initiated sexual intercourse without consent was not alleged initially in the court filings. It was not alleged until 2024. At trial, Laura testified that the parties had sexual intercourse and that it was rape. Laura testified Clayton was too high to remember sexual intercourse due to his voluntary intoxication. Petitioner, try to go. I know she did. She always nopes out when it comes to this part. I believe it. I firmly believe it. I think this is planned. This is coordinated. She reads it ahead of time and says, this is a good one for Buffy to read. Anyways, back to it. Laura testified that Clayton was too high to remember sexual intercourse due to his voluntary intoxication. Laura believes she became pregnant on May 20th, 2023. She testified that after May 20th, 2023, her menstrual period stopped and did not resume until November 2023. Laura has had PCOS since the age of 17 and does not have regular periods. Laura has a history of epilepsy. Laura testified she has been pregnant 4 times. Each time the alleged father believes she fabricated the pregnancy and doctored medical records. On May 24th, 2023, Laura asked Clayton to prepare written purchase offers for 2 properties Laura wanted to purchase in Scottsdale. One was located at 1977 North 67th Street, Scottsdale. The offer amount was $425,000, and the other was located on Lynn Oaks Drive in Scottsdale, and the offer was $699,000. Laura asked Clayton as her realtor to prepare these purchase offers and to submit them to the seller or the seller's agent. Laura prepared the purchase offers, which Laura signed on or around May 24th, 2023. But Clayton never submitted them to the seller or the seller's agent. It is absolutely a conspiracy. It's absolutely a conspiracy against Buffy. It's the first time it's funny, the second time it's funnier, but like it's becoming a pattern. Okay. Laura later asked Clayton if he had heard anything from the seller in response to Laura's offers. Clayton advised he had not heard back from the seller. Laura testified that she advised the real estate board and action was taken. On May 31st, 2023, Laura took a home pregnancy test, which showed a faint positive result. Laura testified that after multiple positive pregnancy tests, she told Clayton she was pregnant. Laura denies using hormones, someone else's urine, or altering the test at all. Damn right, Echoes. Thanks for joining my side.
I'm sorry.
Look, she's already in here protesting. I see it.
I
all
was
over her
busy
face.
calling the cops because the internet is harassing me. And I heard there was going to be a subreddit. So I made sure to report you all to the police. So expect to all be going to jail. Okay. All y'all. No, I'm just kidding.
Oh, guys. Yeah, she definitely heard us talking about her.
Oh, definitely. I didn't do it on purpose. But it is kind of weird.
Yes, you did. Don't lie. Don't lie. It's a pattern. It's a pattern of behavior.
She's figured us all out. Me either, Susie, me either.
Oh, Lord. Laura found Clayton's reaction to be hostile and dismissive.
I wonder why.
On June 1st, 2023, Laura went to Banner Urgent Care at Greenway and 64th Street. She informed the nurse that she believed she may be pregnant, and she asked for a test to determine whether she was in fact pregnant. The test result from Banner Urgent Care was positive for pregnancy. Laura testified that for more than 6 months prior to May 2023, she was not sexually active with any other men. Based on this, Laura testified that she believed she was pregnant and Clayton was the only potential father. June 19th, 2023, Laura went to Clayton's home at his request. Clayton provided a pregnancy test for Laura to take. Conflicting testimony makes it difficult to ascertain whether the test was taken in front of Clayton or with the bathroom door closed due to a shy bladder, and that should have been in quotes. Both parties. I am on 5.
Okay.
Of 9.
Just want to make sure.
Okay. Both parties agree the test was positive. In the something to consider email, the court finds the language to imply Laura or Clayton was attempting to buy into the idea that rubbing or grinding their genitals together. See? None of that was in anything you read.
It's just how it goes. I don't know.
Okay.
I hope my mic's better. Sorry. I don't know why it's adjusted our settings differently. I don't know. It's stupid. But I hope it's better for you guys now. Sorry about that.
Now I have to read it over again. I get to say it twice. Clayton was attempting to buy into the idea that rubbing or grinding their genitals together might have led to a pregnancy. The court, however, does not find the email conclusive that Clayton believed her to be pregnant with his children, but rather an attempt to consider her ascertains. Okay. In the something to consider email, Clayton maintains the lack of sexual intercourse would preclude him from being the father of the fetuses. The email does not deny the pregnancy test was positive. In the email, Clayton suggested that the positive test was a result of Laura's epilepsy medication. Okay, so Laura emailed Glennis Zeman from Barrow Concussion and Brain Injury Center on June 28, 2023. The subject of the email is pregnancy and seizure med.
Question mark?
Question mark, yes. Laura denies sending Clayton an ultrasound video, citing instead that Greg Gillespie hacked into her email and sent the video to Clayton. I'm sorry if you can hear a little Buffy in the background. He's
Do you
very
think we
happy
can, but
today.
not very much? I'm glad he's a happy little baby Buffy. I wonder in her felony case if she is trying to convince her attorney that all 4 terabytes of data, all that stuff is from Greg. It's all Greg. He hacked me, and her lawyer's just like, what? No, stop it. Do you think that's defense she's trying to pull? I do.
Sure. I mean, seems like it till now, right?
A tranquilizer dart, like a blow dart. Sorry. Okay.
That visual.
Right.
So I don't even know where it was. Okay, yeah, it
Greg's
was
a
all
hacker.
Greg. We're all Greg. Laura testified that July 2nd, 2023, she anonymously sought care at a Planned Parenthood in Los Angeles. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, Clayton presumably sought records from all Mission Viejo Planned Parenthoods, as that where up until today, Laura disclosed she sought care. Laura testified that she had the sonogram at a Planned Parenthood in California, either anonymously or under a pseudonym, and changed the location to prevent Clayton from tracking down the records. The court was not provided with those records at trial. Bum, bum, bum.
Wonder why.
Because they don't exist, in my opinion. Okay, so Laura testified that on July 23rd, 2023, she experienced bleeding and passed 2 small fleshy objects, smaller in size than her hand. She took pictures of the tissue and sought telehealth assistance, as one does. Laura testified that she texted a miscarriage hotline and sought telehealth assistance. The telehealth provider told Laura it was hard to tell if she miscarried, as she should monitor the situation and seek further care as needed. Laura chose not to seek in-person care that would have confirmed if she had been, still was, or had miscarried. The court finds the hard to tell component of the telehealth visit was due to the nature of the telehealth and the inability to provide care in the form of an exam, HCG test, blood test, ultrasound, or sonogram. Instead of seeking in-person care, Laura chose to take another HCG home pregnancy test on July 25th, 2023, which was positive. Laura again took an at-home test instead of seeking care on August 1st, 2023. Laura testified, as you do. Like, we just keep testing just to make sure it's all there. Laura testified that she made multiple appointments to see Dr. McCool. 3 of the 4 appointments were rescheduled and then canceled when Laura tested positive for COVID. Dr. McCool's records indicate 44 pages of records confirming making and canceling appointments. 44 pages.
Of just making and canceling appointments. Wow. Oh, by the way, some of you are talking about that article from the Mercury News from, what is her name? Martha Ross. That article. If we have time, I have it pulled up. If we have time, we can read it.
What is it?
It's an article about mostly Ron Warren and her parents have some quotes in here and stuff. Apparently, it is very good according to the Discord server. So
44 pages of calling and canceling. Jeez, Pete's.
I'm surprised they kept like taking her. Oh, I bet the medical. Oh, is it nothing of a nothing burger? Okay. Well, then if we have time, I mean, this is very long. I cannot. It looks like it's a very long article too. So, but yeah, I'm surprised they weren't just like, okay, you know what? We're done here.
Yeah. Like, because it takes an appointment from somebody else who probably needs it. Also,
Yeah.
it's just annoying when it's the same person. 44 pages, not necessarily 44 like appointments, but pages of appointments. How many
Mhm.
per page? I have questions. Anyway,
Too many.
that's ridiculous. I wonder what the receptionist put in the notes. This bitch keeps calling and canceling.
Llama's infamous, this bitch.
Right? I mean, because there are notes on all of us. I know it says,
Sure.
this woman talks a lot. Just get her off the phone. No. The court was not provided with evidence of the positive COVID test, but maintains that the nature of her high-risk pregnancy would warrant a visit to the emergency room who would be equipped to care for a high-risk pregnancy wherein the mother was COVID positive. In August 2023, the parties agreed to a DNA test through Ravgen. Laura paid $725 to Ravgen for the test. But Clayton failed to provide a sample, and Laura canceled the test on August 18th. The court does not find the sexual contact between Laura and Clayton resulted in pregnancy.
Oh, that's
That should
all
be in
right.
bold.
Mm-hmm.
The court finds that if the petitioner, Laura, was pregnant, it is profoundly unlikely that the conception occurred because of rubbing, grinding, or oral sex.
Oh.
During this litigation, if Laura had maintained consistently an allegation of sexual assault coupled with a police report or physical exam, the court may find differently. Evidence and testimony, however, do not support this inconsistent contention. Laura admitted to changing an HCG test result to reflect 31,000. She further testified she altered the document using Adobe, but not Adobe Acrobat.
But
In late
okay.
Adobe Photoshop, not
But
Acrobat Reader.
Not an acrobat.
I don't know why the differentiation, but whatever.
Probably because
Like why she needed to a distinct, but also legal paperwork. In late September, because Jingras would dissect the shit out of that.
Oh,
it was
100%.
not Adobe Acrobat. It was Adobe Photoshop. Get it right, Judge. In late September or early October, both parties submitted samples to Ravgen for DNA testing. October 16, 2023, Laura's blood was drawn, and the results were HCG levels of 102. That's 102, not 102,000. Petitioner changed the results to reflect 102,000. Laura testified that on October 18, 2023, she was aware the alleged pregnancies were not viable and filed the request for pre-decree mediation in the hopes that at mediation she could tell Clayton that the pregnancy was no longer viable. Upon denial of her request, however, she did not file a motion to dismiss or make other arrangements to advise Clayton of the development. The court finds this testimony uncredible and a misuse of judicial resources.
Oh.
Laura was not treated by Dr. McCool or Dr. Higley as testified to in her November 2nd, 2023 hearing on the IAH. Laura's alleged pregnancy was not treated by Dr. McCool, Dr. Higley, or any other in-person obstetrician or gynecologist.
Oh.
Court finds failure to seek in-person care for a high-risk pregnancy to be both unreasonable and uncreditable.
Yes, Judge Mata. Yes, it is.
And
nobody's doing that.
Negligent, if it was accurate, in my opinion.
Mm-hmm.
The court further finds that going to Banner for a pregnancy test, but not the passage of fetal tissue, to be unreasonable and uncredible. A reasonable person, if seeking emergency room care to confirm a pregnancy, would not rely on telehealth to confirm the non-viability of the pregnancies.
Nope. Yes.
What is it? Yes.
Love the clown.
Anyway, Petitioner testifies. Okay, Laura testifies on November 14th, 2023. She sought OB/GYN services from a facility mom doc to determine whether she was allegedly still pregnant. At that appointment, Laura took 2 pregnancy tests that were both negative. Laura testified that she currently weighs 91 pounds, but weighed 133 in November 2023. During her mom doc appointment, she experienced significant swelling in her abdomen and felt pregnant. The court was presented with videos dated September 19th, 2023 and October 9th, 2023. Laura sent Clayton of her abdomen as evidence of pregnancy. Dr. Medchill testified that while she appeared pregnant, that alone was not conclusive of pregnancy. Laura denies tampering with the HCG test, but does admit to altering and fabricating ultrasounds and sonograms.
Mm-hmm.
She further testified that she changed the HCG numbers on 2 of the results. The court finds little, if any, difference in altering the test itself, for which she denies. Hold on. I heard boom.
Right.
And I'm like, I was about to yell, are you okay? But y'all didn't want to hear all that. Okay. Let me go run and check on him real
That's
quick.
fine. I'll pick it up here. All right. So the court finds little, if any, difference in altering the test itself, for which she denies, and altering the results when she did tamper with by her own admission. During Laura's cross-examination, it became profoundly obvious that counsel for Laura was attempting to coach her answers. Oh, that's not great.
Okay.
All well?
Yes. It was just a crash. He
that's
dropped
good.
a flashlight, a very heavy maglite flashlight. Okay.
So
Sorry,
you're
where
on
are we at?
Respondents' Counsel.
Respondents' Counsel identifying the issue, moved between counsel and the petitioner. Is that the one?
Yes.
Okay. From that point forward, Laura began to exhibit extreme anxiety and unwillingness to answer questions. The court had to remind Laura twice that counsel would ask a question and she needed to answer it. At this time, Laura pushed back her chair and advised the court she did not believe she was being treated fairly. The court attempted to redirect petitioner or Laura to no avail. At this time, Laura became emotional and asked for a brief recess, which the court granted. The court finds this interaction between counsel and Laura diminishes the credibility and veracity of Laura's responses during cross-examination. That's interesting.
Nice.
Wow. All right. The court finds it is impossible to determine the date of any alleged miscarriage, not because it is impossible, but rather because she failed to seek even a minimal level of care for her high-risk condition. Failure to demonstrate confirmation of ongoing pregnancy is a purposeful way to ensure Clayton would not be able to determine if she was pregnant, and if so, for how long the pregnancy lasted.
Mm-hmm.
Yikes. Dr. Medchill, a retired OBGYN and prior chair at St. Joseph's Hospital, testified that pregnancy is possible without sexual intercourse. Dr. Medchill testified that he delivered 30,000 babies during his practice and saw many patients for miscarriage. Dr. Medchill testified that he reviewed approximately 200 pages of Laura's medical records from Barrow Neurological Institute in Phoenix that included summaries of Laura's medications. He did not, however, review primary care or historical OBGYN records. Dr. Medchill testified that none of the medication records he reviewed would cause a false positive home pregnancy test. Dr. Medchill testified that a false positive HCG test could be the result of epilepsy medication, anxiety medication, clozapine, horse urine, or IVF prescribed injections, trigger shots. Why are you drinking horse urine?
Girl's got to do what she's got to do to get that back.
I mean, I've never been that thirsty.
No. She said 30,000 babies. I could have swore he said 20,000. I've noticed.
No, he
some amount
said
of-
30.
Did he say 30? I don't know.
Because 30,
already
20,
drinking.
that's still a lot of babies.
Mm-hmm. It's wild.
That's still a lot of babies.
Is that even possible?
Anyways, I don't know. I think it was an exaggeration. Because when he
Okay.
said it, I was kind of going, okay, I doubt it. Seriously.
How many babies is that a day? For how long?
Like how many people live in a, like, that's a whole city.
Right. Somebody do the baby math for us, please, and thank you.
I mean, I guess if you deliver 1,000 babies a year for 20 years, maybe.
Oh, wow. Okay. But still, that's 3 babies a day. 2, maybe 1.5 to 2 babies a day.
I mean, it's possible, right?
I guess. Yeah. I don't know.
I don't know.
It's wild to think about, though.
I need receipts. Anyway, prove it. No, just anyway. So horse urine. That's where we left off. When asked by the court, Dr. Medchill testified he did not review any Planned Parenthood records from Mission Viejo or Los Angeles facilities. Dr. Medchill testified that home pregnancy can detect pregnancy 11 days after conception. Dr. Medchill testified that he is 99.9% sure that Laura was pregnant based on HCG tests. He did not change his perspective after Laura's admissions on the stand that she altered more than one test to reflect higher viable HCG numbers. The court finds Dr. Medchill's testimony that 0.1% chance that petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for HCG, and a prior history of ovarian cancer to diminish his credibility.
Oh.
Especially given that records that Laura testified existed were not presented to her own expert for review and consideration.
So the judge said he's not credible. How many? 30,000.
30,000 babies. But I don't remember for how long he testified, right? Like, or how practiced.
Mm-hmm.
How long was he in practice? I mean, I guess it's possible. I don't know. I don't pretend to know these things. I'm just a girl on the internet reading court documents. Okay.
Yeah. Hi, Wendy Williams. That's wild.
Dr. Medchill testified that a blood HCG level of 102 is proof of a non-viable pregnancy. While Dr. Medchill testified that a non-viable pregnancy is still a pregnancy, the court finds that altering the number to reflect 102,000, which would be a viable pregnancy, to indicate that she intended for Clayton to believe she was still pregnant with viable fetuses. Yes, that's exactly what that meant. Dr. Medchill concluded that the petitioner, Laura, became pregnant on May 20th, 2023, and ended with a spontaneous abortion late October, early November, or possibly sooner in 2023. Given the alterations of the only records to indicate pregnancy, the court does not accept this conclusion. Dr. Medchill testified that women may expel tissue during a spontaneous abortion, or the pregnancy might remain in her body, ultimately being reabsorbed. Given that the petitioner testified under oath at a prior hearing that she was absolutely 24 weeks pregnant
100%.
and they needed to quote, like, absolutely 1,000,000,000%. And had seen her doctor, presumably in person, the court does not accept that 24-week-old twin fetuses would be reabsorbed into a mother's body. No.
I love it.
That's a little much.
I love
The
it.
court further finds a miscarriage at that stage of pregnancy would result in emergency medical care and responding death certificates of the twins. If what Dr. Medchill testified to is true, and she miscarried much sooner, negating the need for the death certificates, then Laura perjured herself at a prior hearing.
Oh.
So you're either lying now or you're lying before.
And the judge wrote it
Which
down.
one is it? Which one is it? Lying now or lying earlier?
I love this.
Dr. Samantha Deans, MD, reviewed Laura's records and provided her analysis of HCG results. Additionally, she was the prior associate medical director of Planned Parenthood in Florida and Pennsylvania. She testified that Planned Parenthood does not accept anonymous patients. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays, when Laura testified she sought care, July 2nd, 2023. Dr. Deans testified that HCG does not confirm pregnancy. There must be serial HCG or an ultrasound and examination, which were never done or never disclosed to the court. Clayton, Dr. Medchill, or Dr. Deans. Dr. Deans reviewed the July 23rd, 2023 telehealth instructions that Laura should proceed to an emergency room for additional evaluation and care. The instructions were not followed, but Laura called the abortion and miscarriage hotline, which also recommended and encouraged Laura to seek in-person medical care.
It's wild. Everybody kept saying that to her, and she just,
I know.
it's so weird. Why would they say that all the time? Every person.
But like,
ever.
is it like a recommendation though? Or should I like do it?
Exactly. Well, they just recommend. They didn't mean I needed to see it. Otherwise, they would have said
It's a
go.
suggestion. Ultimately, you know.
A very like serious life or death situation. You might want to go.
You know, it's your choice. Whatever. Dr. Deans testified that there is no data to indicate a conception date. After reviewing the records, Dr. Deans determined that the HCG tests were never dispositive of pregnancy and that the related miscarriage timeline, which included detailed analysis of the likely origin of HCG in petitioner's blood and urine, was not indicative of human gestational norms. Well, that sounded all fancy.
Laura Owens is here. Speaking of, we've summoned Laura Owens.
The woman of the hour. Dr. Deans testified that the heterophilic autoimmune response due to exposure to animals could produce a positive HCG test, but the confirmation blood test would be negative. A prior history of cancer could also produce a positive HCG result. Laura has a prior history of ovarian cancer that prompted the surgical removal of her right ovary. But does she have her ovaries?
I think she does. I think that was determined to be a lie because she has two.
I'm just going to need someone to make a list of all the lies, please. Because I'm having a hard time keeping track.
Right?
I just need a list, okay? Familial HCG syndrome can also produce a false positive HCG test. Dr. Deans testified that syndrome is very rare, with only 10 known cases in the world.
But
Horse tranquilizers can create a positive HCG result.
Oh.
What are we doing with those, bestie?
I know, right?
Maybe that's what her parents are shooting her with.
The blood.
Right. Allegedly, in my opinion, for comedic purposes only.
Jan just hiding. Maybe that's what Ron's doing.
Ron,
He can't do
she's
anything
at it
else.
Again. He's got one for each one. Is that how he gets peace in his house for a little while? He's just like, allegedly, in my opinion.
Yes.
Maybe I heard a rumor. Okay. Clayton denies all allegations of sexual intercourse. Clayton confirms both parties were under the influence of marijuana, but denies being high and further denies memory loss because of the marijuana ingestion. Clayton testified that around May 22nd, 2023, he realized his behavior with Laura was unprofessional and he intended to discontinue a sexual relationship with Laura. He testified that upon hearing this, that Laura became very emotional.
Really?
Clayton testified that he told Laura he had submitted the offers to the seller. Clayton testified he did not believe that Laura was really interested in the properties. When asked if he had received any response, Clayton told Laura that he had not, but he never told Laura the reason why no response had been received is because the offers had never been submitted. Clayton made knowingly false statements to Laura about the real estate purchase offers. Clayton testified that Laura sent him approximately 500 text messages using 13 different phone numbers, threatening to leak information to the media. Clayton testified that Laura reached out to the son, called his family, coworkers, and prior girlfriends, accusing him of being a deadbeat for not supporting her and the twins. Clayton testified that he received the video from Laura and continued to correspond with her over that email string, which would reasonably prompt Laura to advise she did not send the video, but she did not advise of that at the time. Interesting. Laura emailed Clayton, "You can't say you haven't been given a voice when I have told you that I will have an abortion if we try things out for a few weeks and have a good reason for aborting the child."
Isn't that such a good reason?
I mean,
what?
It sounds completely irrational to me.
Totally.
I don't know why you're having so much trouble with this, Llama.
I know. Gosh, it's crazy.
You just have to think about it the way that I do.
With intention. You're right. I need to go in this with intention, an open mind, and she will show me.
See, now we're working progress. Now we're making progress.
And she will show me that I will like her if I just give her a chance. Is that right?
Just 7 days. I hear it in 7. It's like The Ring. 7 days. Does the girl come out of the TV and kill you?
But they're like long hair. Yes. So she hasn't.
Okay. Well, these words feel menacing because I like you. I want to try things out with you.
Yeah, just a little bit.
The email continues. You would be obliging to make the decision to date exclusively before deciding whether or not we have an abortion. Okay.
It's fine. It's a totally normal thing to ask.
Yeah.
Totally normal.
Totally how things work in real life. Okay. Laura encouraged Clayton to have sexual intercourse with her, citing she was tight. See? And already pregnant. I'm tight. No, you know what? I think that needs to be a maternity shirt for every pregnant woman. I'm tight and already pregnant.
Right? Wild to say that. Wild. Also, it's not a thing. Like, what the fuck? Oh, she's a grown-ass woman. It's wild to me.
It's still reading this is still like, Jesus. Laura further emailed Clayton that he had control of the outcome of the pregnancy if we date exclusively and care for each other. On June 28, 2023, she said, "If you think about it, having sex with me is the safest thing you can do at this point."
It is not. PSA to the world, anybody listening now, it is not the safest thing you can do at any point, based on everything we've read so far. So,
I'm already pregnant, and if we choose to go this route and trust each other enough to have sex, then we are at the point where I would be taking abortion pills. So there's no risk.
It's wild.
Okay. Laura told Clayton the twins were a boy and a girl. Laura provided Clayton with a sonogram that was posted on YouTube 7 years ago. Laura admitted to this during her deposition. Laura sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action that she initiated. Laura signed a release of records to Dr. Jeffrey Blake Higley, MD, at Women's Care. In a letter dated March 18th, 2024, the provider advised, "We have no record of treatment for the dates of service you request."
What are the
Bum,
odds?
bum, bum. Didn't see that coming. In this case, the gravamen, I'm going to look that word up, of Clayton's position is that Laura has fabricated her pregnancy, a condition which cannot have resulted from the parties' interactions because, according to Clayton, they never had sexual intercourse, but he does admit that the pair engaged in oral sex. Clayton seeks to have the protective order invalidated based on the alleged fabrication, while Laura essentially argues that even if she was never pregnant, the sexual activity between the two and Clayton's subsequent harassing online conduct are sufficient to sustain the order regardless. There is a predicate issue that should be addressed, which goes to the court's authority to reconsider the protective order at all. Put simply, extant appellate authority, namely Vera versus Rogers, and like cases, precludes reconsideration here. In Vera,
story time.
Mother applied for a protective order in Phoenix Municipal Court, but it was eventually transferred to the Superior Court after Father petitioned to establish legal decision-making authority, parenting time, and child support here. After a contested hearing, the commissioner handling the order of protection affirmed in its entirety. Okay. Father, that seemed like it should have had more, but okay. Father then filed special action after the Court of Appeals to order the family court to amend the order of protection to align it with the temporary parenting time orders it had made in the separate case. The Court of Appeals accepted the special action, finding it raised a purely legal issue of first impression that is of statewide importance, to wit, the interplay between the procedural rules and statutes governing protective orders and family law proceedings.
Why did we put this as a different color font? What is happening here? Sorry, I notice these things. It bothers me.
I don't. Wait, where is the different color font?
We're looking at it right now. It's a lighter gray than the black. It is.
Oh,
well,
see,
you're also colorblind, so
it does make it a little more difficult seeing things. Like it looks the same to me. I don't know.
No, from like this point on, it's this lighter gray color. Where the rest of it was like black. It's significantly different.
I'll take your word for it. It looks exactly the same to me.
It's not though.
I mean, usually I can tell shades, but it doesn't look different to me. Okay, so the Court of Appeals first recognized that the Superior Court, pursuant to ARFLP, has the authority to hold a joint hearing to concurrently consider both actions so that it may harmonize the orders. But having said that, the court noted that the Superior Court's authority to modify an order of protection only exists pursuant to the statutes and rules controlling the protective orders. And those statutes and rules prevented the relief Father sought in Vera because another Superior Court officer had already affirmed the contested order of protection.
So Amy did some math for us about Dr. Mitchell. He was in practice for 41 years. So to hit 30,000 deliveries over the course of 41 years, he would have had to deliver 732 deliveries per year. That is 14 deliveries a week. And he said a lot of his time was spent in charge of the department or whatever you call it. I don't know medical stuff. No, I don't know anything about Blake Lively stuff. I mean, except for the few headlines I read, but other than that, I have no idea what was even going on there. So look at that. You have many on your side. As another colorblind woman, it looks the same to me too.
I would say I don't see it either. But I'll take your word for it. We're rare. We're rare.
You are. Rare little unicorns, you guys are.
So let's see.
Unlike Laura.
We're a special little breed.
You're on Indeed.
So, indeed, the court stated that once a contested hearing has been held, an affirmed order of protection may be amended or dismissed only in two ways: by a request of the party protected by the order. Arizona R protective order. I'm not going into that. By appeal. Let's see. By appeal, and is there a 3? I don't see a 3. Because mother had not requested amendment and father did not appeal from what amounted to a final judgment, he could not obtain a relief. And the family court had no power to amend the protective order. But another way around, a superior court judicial officer is not to engage in horizontal appellate review of another judicial officer's decision to affirm an order of protection. Holding that a superior court judge has no jurisdiction to review or change the judgment of another superior court judge when the judgment has become final. Can we just have shortened that up and just like wrote that sentence? I would have believed you.
I just
I'm just saying. Just like in Vera, absent a move by petitioner to modify or dismiss the protective order, respondents' sole remedy was to appeal the final ruling, affirming it after the contested hearing. Although Vera did not involve fraud, this court was unable to identify any cases collaterally challenging a final protective order judgment on Rule 85 grounds in a separate family court proceeding, nor any authority suggesting that Vera's exclusive roadmap, which is rooted in ARPOP 40 and 41, for amending or dismissing a final order of protection judgment is subject to an exception based on Rule 85 review. This court's power to invalidate the order is foreclosed by Vera. You could have just wrote that. You could have just wrote that and we would have been fine. But I didn't need all that. Even if Vera did not foreclose this court's review, respondent cannot prevail here despite what appears to be a case of serial fabrications here and elsewhere by petitioner. Under ARS 133601, the parties admittedly had a relationship that was previously romantic or sexual, however fleeting it might have been. Laura thus had a statutory avenue to seek a protective order, regardless of whether she fabricated her pregnancy. Moreover, Commissioner Duty did not issue the order based solely or even primarily on the fact of petitioner's pregnancy. Indeed, his initial order required that Clayton not contact Laura or communicate or post untrue or harassing comments regarding Laura online, including but not limited to social media, and shall not cause others to do the same. Moreover, Laura's initial petition referenced a myriad of communications Clayton made to her that could be deemed threatening per the statutory guidelines and appears to have been prompted Commissioner Duty to confirm the order after the hearing. Thus, even if Laura's broader pregnancy allegations are proven untrue, one aspect of the court's order indicated that if found, Clayton had engaged in harassing conduct. So even on the merits, there is no cause to invalidate the final judgment.
I respectfully disagree, Judge Mana.
I
was bogus in the first place, but I get it. There's certain
trash.
It is trash, but all right, fine.
Her words are trash. Vera versus Rogers forecloses not only reviewing the orders in principle, but also prevents tinkering at the margins as well. If the superior court cannot engage in horizontal appellate review of another judicial officer's decision to affirm an order of protection, there is no way that the court can otherwise review portions of those decisions piecemeal either. The parties' remedies as to both decisions were to appeal and have the appellate court review the entirety of those decisions. Both had hearings as to their respective orders, and under ARPOP an order of protection, an injunction against harassment, or an injunction against workplace harassment that is entered, affirmed, modified, or quashed after hearing at which both parties had an opportunity to appear is appealable.
Which he did not appeal. And I think
No, and
that's
he
her
should
argument
have.
there. And I mean, she's not wrong. Do I like her answer? No. I don't like what happened in the first place, but that's the thing with
But he
rules.
could have appealed
Like
it.
we were saying, with Reckless Ben and the ban thing, like there are rules. Like if you don't know the rules of the game, you can really fuck yourself over. It doesn't matter if the ruling we think is bullshit or whatever. It doesn't matter. They have rules that you have to follow and processes of how to do things. And unfortunately, that's what happens a lot. So that's why you have a lawyer, because they know which rules you have to abide by, which things you have to do next in order, because the judge really cares about order of filings and documents and all of that.
Right. ARFLP 26 provides that by signing a pleading, motion, or other document, the attorney or party certifies to the best of the person's knowledge, information, and belief formed after reasonable inquiry. 1, it is not being presented for any improper purposes, such as to harass. The claims, defenses, and other legal contentions are warranted by existing law, and the factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Meanwhile, Rule 26 provides that if a pleading motion or other document is signed in violation of this rule, the court, on motion or on its own, may impose on the other person who signed it, a represented party, or both, an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including a reasonable attorney fee. Emphasis added. In this case, Clayton filed a motion for sanctions pursuant to Rule 26 on January 3rd.
We were so close to having a good day.
No.
So close.
We have to have, it's going to be mentioned like 100 more times as I'm just kind of skimming through this document.
Oh.
For fuck's sake. Okay. In this case, Clayton filed the motion for sanctions pursuant to Rule 26 on January 3rd, 2024. Arguing that Laura filed the underlying action for an improper purpose without medical evidence to support her claim that she was pregnant or that she was pregnant by Clayton. However, after significant motion practice between the attorneys, Clayton filed a motion to withdraw motions for sanctions pursuant to Rule 26 on April 3rd, 2024, while retaining his other claims under ARS 25. The question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion?
Oh boy. Okay. I mean, I want to hear what the judge says, but also my brain heard Rule 26 and is like shutdown mode.
Right? I'm like, can we fast forward to
Just
what
say yes
she
or
came
no.
up with?
No, just kidding.
Like, could it really have just been a TLDR? Yes. No.
I think so.
It could have. As already noted above, ARFLP 26 expressly provides the court can sanction a party for a violation on its own. The court was unable to locate any decisions pertaining to whether the withdrawal of a party's Rule 26 sanctions motion precludes a sua sponte court award. But as a matter of plain meaning and strict interpretation, it would seem not to matter whether a party ever files a motion or even whether that party does file a motion and then withdraws it. A court may still award the sanctions it deems appropriate based on the conduct it deems to violate the rule. Indeed, if per Rule 26, the court can at any time award sanctions of its own accord, and on its own findings, absent invitation, the withdrawal of a party's motion to do so would not seem to vitiate, I don't know that word, or in any way affect that power as a matter of plain logic.
Oh.
So, for instance, if the court were to find that Laura fabricated her pregnancy to provide leverage against Clayton in order to secure a long-term relationship with him and all its attendant benefits, Rule 26 would appear without a doubt to provide it the authority to order her to pay Clayton's reasonable expenses, including reasonable attorney fee.
Oh, looks like somebody is getting ready to tell them you're going to pay. You're going to pay today.
Right?
Yikes.
Regardless of any prior filings by the parties. That is because that fabrication, if adjudicated, as such, would have been the predicate for her initial petition and many, indeed all, of the motions that came after it. Although there is a dearth of case law on this issue, other rules confirm that the family court has the authority to award sanctions on its own. Rule ARFLP 76.2, for instance, provides that in a pre-judgment or post-judgment proceeding, the court, upon motion or its own initiative, may impose sanctions if a party or attorney fails to obey a scheduling or pretrial order, fails to appear at a resolution management conference, a scheduling conference, an evidentiary hearing, a trial, or other scheduled hearing, is substantially unprepared to participate in a conference, hearing, or trial, fails to participate in good faith in a conference, hearing, or trial, or in preparing a resolution statement, scheduling statement, or pretrial statement. Emphasis added.
Ooh.
And the remedies available include, in addition to substantive actions, ordering the party at fault to pay reasonable expenses, including attorney fees and assessment to the clerk or both, caused by any non-compliance with a court order. Okay, so bunch of court stuff, confirming power of court to award sanctions on its own, blah, blah, blah. Okay, I don't think we need that. Additionally, as is evident from their near textual identicality and per the Arizona Family Law Rules Handbook, ARFLP 26, is based on Arizona rules, civil procedure, comparison with civil rules, blah, blah, blah. Family
We are
okay,
back.
wow,
And I scanned ahead and there's not blowjobs coming up. So,
oh, goody.
I'll put up here.
Okay. And Rule 11 also expressly provides that in the event of a violation, the court, on motion or on its own, may impose on the person who signed it, a represented party, or both, an appropriate sanction. And in Rule 11 context, the Court of Appeals has concluded that a trial court may impose sanctions even after a complaint has been dismissed for lack of prosecution. See Britt versus Stephan. This lends credence to the idea that the family court's inherent authority to award sanctions under ARFLP should not be read to be limited by the course of the case or by the litigation strategy pursued by the parties. The power is there by rule and can be used by the court when necessary and appropriate. ARS 25-814 provides a man is presumed to be the father of a child if genetic testing affirms at least a 95% probability of paternity. ARS 25 provides a man is presumed to be the father based on DNA testing that may only be rebutted by clear and convincing evidence. Based on a lack of confirmed pregnancy and repetitive ravaging results of little to no fetal DNA, the court cannot establish that the petitioner was pregnant. The court cannot establish paternity of a non-confirmed pregnancy lacking DNA evidence despite testing twice. Here, two results of little to no fetal DNA fall woefully short of the 95% required to meet the burden of clear and convincing evidence that respondent was the father of Laura's alleged pregnancy. Attorneys, fees, and costs. Clayton Echard has requested an award of attorney fees and costs. An award of attorney fees and costs is governed by ARS 25, and it provides as follows. The court, from time to time, after considering the financial resources of both parties and the reasonableness of the positions each party has taken throughout the proceedings, may order a party to pay a reasonable amount to the other party for the cost and expenses of maintaining or defending any proceedings under this chapter or chapter 4, article 1 of this title. On request of a party or another court of competent jurisdiction, the court shall make specific findings concerning the portions of any award of fees and expenses that are based on consideration of financial resources and that are based on consideration of reasonableness of positions. The court may make these findings before, during, or after the issuance of a fee award. If the court determines that a party filed a petition under one of the following circumstances, the court shall award reasonable cost and attorney's fees to the party. 1, the petition was not filed in good faith. I don't think it wasn't. The petition was not grounded in fact or based on law. Survey says not founded in fact or based in law, and the petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. I feel like all three apply here. For the purposes of this section, costs and expenses may include attorney fees, deposition costs, and other reasonableness expenses as the court finds necessary to the full and proper presentation of the action, including any appeal. Ooh. The court may order all amounts paid directly to the attorney, who may enforce the order in the attorney's name with the same force and effect and in the same manner as if the order had been made on behalf of any party to the action.
Oh, I agree.
What? I agree. I felt like it covered all three bases. The court finds there's no substantial disparity of financial resources between the parties. Really? Petitioner did not provide an AFI, but testified she and her mother collectively earn $200,000 a year. Respondent filed on AFI on May 15th, 2024, citing monthly income of $12,000 and an annual income of $144,000. The court further finds that petitioner acted unreasonable in the litigation. Specifically, petitioner acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound sonogram physical examination, and in conjunction with the belief she passed tissue in July 2023. The court finds the underlying petition premature at best. At worst, however, fraudulent and made to incite communication, a relationship, or both with the respondent. Oh, but premature at best and fraud and the worst. Ooh, that's a deep cut, bro. That's deep. The court further finds that the filing a motion seeking mediation for the purpose of telling the respondent that their pregnancies were not viable, disingenuous at best, but certainly misleading to the court. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. Either way, respondent likely incurred costs associated with this litigation prior to retaining counsel, and he is entitled to reimbursement for those costs, which he'll never get.
No.
The court further finds that Laura repetitively failed to comply with Rule 49, different rule, even on order of this court. Further compounded by the fact that on the day of trial, she testified that she anonymously sought care at Planned Parenthood in Los Angeles, while she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias. Clayton presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, Laura disclosed she sought care. This undoubtedly caused Clayton to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appeared to have never existed in Mission Viejo. Additionally, Laura acknowledged she altered HCG test results and an ultrasound sonogram. The court further finds that the provisions of ARS 25 blah 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 do apply because the petition was not filed in good faith. The petition was not grounded in fact or based in the law.
Or reality.
The petition was right. The petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Here, the court finds Laura provided false testimony as to the viability of the pregnancy in all 3 cases addressed in the procedural history. Additionally, prior to her deposition, Laura sent a threatening letter to Clayton indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss the action that she initiated.
Right. She's so dumb.
Wow. The court further finds that Laura Owens, we're going to put her full government name out here, that Laura Michelle Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney fees and costs is appropriate under ARS 25. It is therefore ordered granting Clayton Echard's request for attorney fees and costs associated. It is further ordered denying Clayton Echard's request for attorney fees and costs associated with the order of protection and the injunction against harassment hearings referencing the analysis above. It is further ordered that Laura Michelle Owens shall pay Clayton Echard's reasonable attorney fees and costs not later than July 8th, 2024. Oops.
No later than, so like a week from this. Oh no, I guess this is the 17th?
Yeah. But it is June 30th, 2026.
No, I meant from when she filed it.
Yeah. I'm just saying, like, she's
she
late.
Still hasn't.
She's still late.
Still super late.
Clayton and counsel for Clayton Echard shall submit all necessary and appropriate documentation to support an application for an award of attorney's fees and costs, including a China doll affidavit and a form of proposed order by no later than July 29th, 2024. Laura Michelle Owens shall file any written objection, and she will, believe me. She's going to file it all over Medium. She's going to put it all over her blogs. She's going to object all over the internet.
All over the place.
Shall file any written objection and a form of proposed order. If Clayton Echard's counsel fails to submit the documentation by July 8th, 2024, no fees or costs will be awarded. The court shall determine the award and enter judgment upon review of the affidavit as well as any objections. Additional orders. It is further ordered granting the respondent's petition for non-paternity. It is further ordered the court, having determined that Laura Michelle Owens is a liar, has a pattern of similar, if not identical behavior and court involvement, referring this matter to the Maricopa County Attorney's Office for review of Laura Michelle Owens' actions pursuant to ARS 13.
I love it. Love it.
Accordingly, the Maricopa County Attorney's Office will be endorsed on this order. The court must decide the amount of attorney's fees and costs to be awarded, but finds there's no just reason to delay making a final order. It is therefore ordered, pursuant to Rule 78, Arizona Rules of Family Law Procedure, that this is a final judgment. It shall be entered by the clerk. The time for appeal begins upon entry of this judgment by the clerk. For more information, click my link in bio. No, I'm just kidding. It is a further order denying any affirmative relief sought before the date of this order that is not expressly granted above. So it is written, so it shall come to pass.
I
That
like
was a
that.
lot.
It was a lot. It was a lot. But I appreciate her level of calling her out on her BS. So I do appreciate that a lot. Do you think that Laura took it very seriously when it said that they were recommending her to the district attorney's office? I don't think so. I think she's like,
I know. She's
for
taking it as
what?
seriously as she's been taking it.
Like, you don't
I
want
don't-
a judge to say, hey, by the way, I'm going to the district attorney about you, because you don't want
I
that.
feel like I would have kind of freaked out.
Oh, yeah.
If I'd have seen
for
this ruling and I
sure.
saw it, I'd have been like, oh my God. Oh my God.
You
Oh, I'm
done
so
fucked up.
fucked.
So fucked. Right? What is a slam pig? Oh, so we learned about it on The Real Housewives of Rhode Island. Apparently, because one of the other women called the other one a slam pig, which we won't talk about Real Housewives right now, but the reunion was amazing last night. Anyway, apparently a slam pig is an ugly or overweight woman who basically gets used for pump and dumps. That's the term. I'm just saying that's just what you asked what it meant. And that's what it means.
That's offensive.
Yeah, but also kind of hilarious. I should end with good day, sir. Right? I said good day. Pumping what? Yeah. You heard pumping and dumping. Wow, that was glorious to read. It really was. I mean, I get she couldn't do anything about the OP hearing that, because they were asking Mata to override that, and she's like, I can't. It's not how it works.
Yeah.
But
She could have made that so much shorter, though. I didn't need all that. I mean, I know it's documents and she couldn't, but like there should be like the legal document and then here for everybody else. No, I need the TLDR.
But the fact that like she said she was not pregnant. She was never pregnant. The court finds she was never pregnant. The court finds that what she even said doesn't make any sense. It was unreasonable. And what was the other one? She unreasonable and
Incredible.
Incredible. She said that numerous times about lots of things. So
And
I think
you
that's really
are a liar.
And beautiful legalese.
Liar.
Right? Wow. And so she does just that. She does recommend Laura to the district attorney's office. And we'll
And
later
here
find
we
out what
sit.
happens. But here we are. We
2
know what
years
happened.
later.
And we're waiting for her to go to trial for 7 of them.
Still waiting.
Ooh.
Can you
Yeah.
imagine reading this in 2024? I mean, I get why everybody's so frustrated. It's like you got this on almost 2 years ago to the day. Like it's written June 17th. It's June 30th now. And it's 2 years later. And we're still waiting for everybody to get there. And yours is still not going to get there, at least not, in my opinion, probably till the end of the year or closer. But I can see why everybody is so frustrated.
Oh, I think it won't be till next year. But
I said
then-
the
'cause then
earliest it'll be the end of this year.
well, yeah, but then you get close to holiday calendars and
I
court.
said at the earliest. That
I know.
doesn't mean it's
I
going to
know.
happen.
I know. But that's exactly, I mean, that is what happens with criminal cases. I know a lot of
Yeah.
people are upset and annoyed, but it just is how it is. You know, you got to make sure both sides are prepared. Trust me, we know this bitch loves appealing stuff. We know it. She will, no matter what. You just have to give her
She will
not
sit
good,
in that cell
right,
and
every day.
scribble all day.
So,
writing
I
out her
mean,
appeals.
I would rather push it out, get everything where it needs to be to go to trial. So that way she doesn't have any grounds for anything in her appeal. I mean, Buff and I have talked about this off screen. What is surprising to us, because we watch a lot of trials, we've been doing that for years. And what's interesting is the lack of documentation, documents filed in this felony case. Like there's literally almost next to nothing. And it's not because it's a sealed case.
Yeah.
I mean, even with sealed cases, the most basic filings will be available. There's like literally not a whole lot's been
Nothing.
done. Because I do believe both sides thought she was somehow they still thought she was a reasonable person who would probably do what anybody else would do in these situations. But I wouldn't be surprised if we start seeing some more, maybe, just in case, by the state at least. It's kind of wild, right? Because they also want to put in, defense wants to file motions to suppress evidence, motion and limit. I mean, there should be so many court filings, even at this point, and there isn't, which is what does lead me to believe we are looking at definitely next year because judges have
I
to rule
agree.
on these things. They have to be support. If they're not, then that does give her a good grounds for ineffective counsel because it is what's supposed to happen. But I don't think her lawyer is ineffective. One, I do think he knows who his client is. There is no way that every lawyer in Phoenix, Arizona, metropolitan Scottsdale area doesn't know who the fuck Laura Owens is. They all know. They have to know based on all of the different cases, what happened with David. Like, I live in a big city. I know all of the lawyers know every single other lawyer pretty much that works in the city, and it's a lot. Like, we have like 1 million people. But when one of your colleagues has done some wild shit on the internet, I assure you, a lot of them. And she's used so many different firms too that they all know. So he knows
Yeah. Oh,
who
yeah.
he's up
They
against.
definitely go to lunch and brunch and
Yeah.
say, let me tell you, has she called you?
100%.
It's a no, dog.
100%.
I'm telling you, it's a no.
Now, he may be foolish in thinking, oh, well, she's going to listen to me about taking this plea. He may be foolish in that and not really comprehend.
I'm not like other lawyers. I'm a cool lawyer. She'll listen to me.
I don't foresee him being around very long because of the amount of money it's going to cost her to keep him on for the case. With that much evidence to go through, no way she's keeping that guy.
She'll fire him, go back to having a court-appointed attorney.
A public defender.
Yeah. Court, I mean, either one could be court-appointed.
Yeah, and I will say, in the ones we've watched, trials we've watched in the past, the judges usually seem to be a little bit lenienter on.
They're leaner, also physically fit.
They seem to be more lenient on public defenders being ready because they do know their caseload and they know a defender was assigned. They didn't get it necessarily. They work with them a little bit more because they are a public defender compared to a private, because the private attorney agreed to take the case. They didn't have, if they were too busy, then they shouldn't have taken on a client. But with public defenders, that's a whole different ballgame. So I think she is going to end up doing that also to delay things. So, but there ain't no way she can afford the attorney she has to go all the way to trial with
not
him.
with 4 terabytes of discovery.
Yes.
Whatever. Good Lord.
Right, LMP, I agree. I think the state figures she'll take the plea. It's the sensible thing to do. Laura said, "Hold my Red Bull. I'm about to show you all just how
Believe it was a monster. Get it right. No, I'm just kidding. Believe it was a monster, but
Echo says, have the public defenders do the heavy lifting for free. I mean, yeah. Yeah.
I mean, yeah. I don't
but
know, man.
Even then, they're still super limited in recent. Public defenders do not have access or the budget that the prosecution office has. It's still very, like, they have to ask the court for money to hire an expert. If you're you have to ask the court for money to defend your case. The state doesn't have to do that. They can hire whoever the fuck they want, whenever they want. They don't have to ask for anything. So, it is not an even playing field between prosecution and public defenders at all, where the state has an endless amount of people to do. They have their own investigation office, and that's who's going to do their legwork, is the public defender's investigation office, which is what a lot of cops go and do after.
The government says it will give you an attorney. It didn't say it'll give you a good attorney.
Right, or an available one.
or the money
or the
that you
money
need.
to do it.
They just said an attorney.
Yeah, pretty much. That's how it works in a lot of places. And I will not talk shit about a public defender. I mean, there's some not good ones, sure, but their caseloads are unbelievable. Because guess what? It's a lot of poor people going to court. So they're very, very busy people. I know. Isn't it weird how that works
Doesn't
out?
make
It's
any
so
sense.
weird. Wonder why
No
that is.
sense.
But I do think that's going to be her game plan because her family doesn't like paying for things. So they'll drop this lawyer, I bet, gives her a quote this week of what she's looking at to go through all this evidence, what it's going to cost for a trial, all of that. And she is not going to keep him around. How much do you think it would cost? Well over $100,000. Well over.
More than that.
I mean, yeah, that's like lowballing. It's like super lowballing.
Minimum. You're talking about all the time to going through 4 terabytes of data, plus your trial time. That's trial prep, but trial time. Like you get paid for being in court too.
Every day. And it's expensive.
And for everybody he's got with him in court. It's not just one. It's the paralegal that sits next to him. It's whatever. Just you're paying for everything.
I would never say cheese. I mean, I've seen some bad public defenders. I have, but respectfully, the public defenders are always working their ass off and just trying to do their best.
I would never speak bad. I don't. I think they are not resourced enough. They are spread so thin.
I agree.
I feel awful. Like they do what they do what we need them to do. Like everybody deserves a defense. Yeah,
I think the majority of public defenders too. I mean, listen, the money is not in being a public defender. It's not. Any of them will tell anybody that. They're not. If you're a public defender, you are not in it for the money because it is not enough money for all the work you have to do. So usually the people that are there because they do care about the law. They do care about justice. They do care about people being represented. Because a lot of people oh my God, one of the most annoying things when we watch trials is, especially when somebody is a public defender, they're like, well, why is that lawyer representing them? They should know, but blah, blah, blah. And it's like, well, first of all, we want everybody to have representation. 2, as a public, you don't have a choice at all. And you're there to make sure that their constitutional rights are upheld. It doesn't matter if they think that they're guilty, not guilty. It doesn't matter. That's what their job is. And everyone deserves that. And oh my God, I'm like, they don't even get to choose. Like a private attorney can just kind of drop a client if they want to. A public defender, not so much. The court has to approve it. You have to have a fairly reasonable answer. I mean, private attorneys do too, but also if they're like, my client can't pay, well, okay. So you'll never see me, but I will say when somebody's being a bad lawyer, because some of them are in fact bad lawyers.
We do call out bad lawyering.
Yeah, and on the state too. On the state
on both sides.
Right?
We don't differentiate. We don't discriminate. We will talk shit about both sides.
I mean, there's like bad people in all jobs, so that should probably have different jobs. Is what I mean. I don't mean like bad people as in like people, as a person.
Don't backpedal. There's bad people in all jobs.
What? I don't need to spend 20 or 30 minutes backpedaling because
don't backpedal.
Shit came out of my mouth. Sorry. Just trying to be consistent, as the cool kids are saying. LMP says, I do think that on the interest of fairness, public defenders should have access to the same resources as the state. Absolutely. It won't help Laura, but someone who's truly innocent needs that. Yeah, I mean, it's wild, the budget discrepancy between the two. That's why everyone's always like, get a lawyer. It doesn't matter if it's a public defender, a private attorney, because the state is and will always be Goliath. Always. I mean, it's the government. So if you think you can outdo the government, okay. Okay. It doesn't quite work like that. So LMP says, Ian Runkle gets asked all the time, how can you defend someone you know is guilty? He said many times, it's not the guilty ones who keep you up at night. It's the innocent ones. Right. Exactly. It's not very often that I think guilty people really get off on their crimes. Usually they have the private attorneys. But it is the innocent ones, right? Or ones that are being so outlandishly persecuted, like to levels where you're like, what? That's not even fair in the slightest, And then you see others, it's a whole justice system is frustrating. It is. Is it all fair? Nope, it's not. But nothing, if it was, that'd be great, but it's not, and it never will be. It hasn't in all of human history. So that's Gracie. Hello. Says if her lawyer hasn't been able to access some of the evidence, and according to him, no one before him has, does Laura even know what they have on her? I don't know, but she should know. They have everything, Laura. If you haven't figured that out, they got it.
I'm not sure I believe that, because if you listen to the hearing, and he's like, it seems like there's a lot to substantiate perjury, or there's a lot. I'm like, okay, yeah, and I'm sitting here going, okay, so you've seen something.
Mm-hmm. Yeah, and I did appreciate him throwing the other attorneys under the bus. There was like 2 others, and they were around for like a month. That's not enough time for any lawyer, regardless, to get everything all done for a case like this. I think that was just a little bit of deflecting on his part, because when he first came on, he was like, I'll be ready for trial. Sure. Let's go. I'm an all-star private attorney. But I was like, really? You're going to throw the others? You haven't even clearly, you haven't even been going through these terabytes of information. You have not filed any paperwork. And I think he may be the one that's been on the case the longest out of the other attorneys, unless I'm wrong, which I may be. But still, like, what? Really, sir? Let's just be honest here. You need more time. It's a lot of information, and it's fine. But that's what I think is going to be happening in the next few months. So I want to go buy plane tickets for Arizona anytime for the rest of the year.
It's not happening.
No. Or Buffy and I can plan to cover it every month, and it'll get pushed, because that's what always happens. Whenever we go to pick a trial, every time.
It's true.
So we are jinxed there.
It's because I had the thumbnail made.
Yes, always. Well, you guys, that is all we have for you today. Members only, besties and higher. We have the fun roulette night tonight at 7 p.m. Eastern. I think we'll spin the wheel. Maybe we'll do some games, some all sorts of weird, silly stuff for about an hour. And then tomorrow, do we have anything going on tomorrow? I don't think so. Because I think
you took a Wednesday off.
I know. Because I've been working like every day for a while. I needed an easy day. Oh, no, tomorrow morning, for our bestie levels and higher, you have coffee with Terry and Llama, me, at 10 a.m. Eastern tomorrow morning, which will be fun. We'll just be hanging out. It'll just be like, hanging out with your girlfriends. And then we will be back on Thursday at 10 a.m. for more Laura Owens. We're going to read another Jingras blog, and then a whole lot of Laura blogs that are filed right after Judge Mata's ruling came in. So I can't wait to read them. I am sure Laura is like, yes, you're right. I am going to change my ways. No, I don't think so.
No, I don't think so either. I think she's doubling down.
Hold on. Let me see before we go. Let me see how many exactly we have.
There's like 3
to read tomorrow. We got Jingras
5.
1, 2, 3, 4, 5 Laura blog posts that happened between June 19th and June 26th. Oh my
God.
5. Would you guys like to hear the titles before we go, in case you don't know? All right. Well, I'm going to say them anyway. So Laura has one, when judges play doctor. Don't tell me I wasn't abused. You weren't there. Dear JFC cult, let's talk about yours. Too honest leader.
That was supposed to be, yeah.
What's fine?
Usually you put it under big subheadings, and you have like Thursday written in little tiny letters.
I know.
And I was
in fairness,
didn't see it.
That's fine. When common sense is overruled and hunted by hate, surviving a vicious smear campaign. So I can't wait to read this bullshit on Thursday.
Right.
It'll be a fun day, friends. So you don't want to miss that. A lot of them are copy
girl.
pasting parts of each other. Good. I can't wait to make fun of them all and be like, look how unoriginal your outrage is.
Why?
Like,
Then why? Like, why write so many if you're just copy and pasting parts from another one?
so she can call the police and yell at them about the internet.
That doesn't even make sense.
Nicola donates to the Innocent Project a lot. The Innocent Project. I mean, I've covered a few cases where there are people, I believe, who are factually innocent. They're not popular opinions, but it does happen more than anyone should really be comfortable with, quite frankly. And that's why I believe in transparency of the courts always, including allowing video in the courtrooms. That's why I ask when people are logging into WebEx or whatever, be respectful of the courts because they want any reason they can find to not allow that to happen at all anymore. I mean, some courts have quite the opinions. Others are very embracing the openness, and don't even get me started on the federal courts. I don't know why those aren't allowed to be filmed.
I
The
feel like
biggest
those
government at all.
especially
Exactly. What?
need to be.
I have strong opinions about that.
I as well.
Exactly. No cams in Fed court. Really? Why?
Why? What's happening there you don't want us to see? That's the way I feel.
I don't like it. I don't like it. All right, friends. Well, maybe I'll see members tonight and tomorrow morning, but for the rest of you, I will see you on Thursday at 10 a.m. Eastern. And until then, go forth and be amazing. All right. All right. Bye, friends.